All right, if folks could please take their seats, we're going to begin shortly. If folks could please take their seats and cease conversation, we're going to begin shortly. All right. Good afternoon, everyone. Welcome to the joint hearing of GLE and Triple E. I am Chair Melissa Wells, and I will let my colleague from the Senate introduce himself.
Okay, I'm Brian Feldman, Chair of the Education, Energy, and Environment Committee, which also has jurisdiction over election law.
Okay, so this afternoon we have two bills to be heard. We are going to first begin with HB 2101, Arbitration Reform for State Employees Act of 2026. And we have only one in-person testimony this afternoon to present the bill, Ryan Bishop. Good afternoon, Mr. Bishop.
Good afternoon, Madam Chair, Mr. Chair. I am Ryan Bishop, from the Director of the Office of Policy Analysis for the Department of Legislative Services. I'm here to briefly testify on House Bill 2101 and Senate Bill 2101. Based on an opinion of the Office of the Attorney General, these bills address an issue that arose with the enactment of Chapters 155 and 156 of 2026, which were House Bill 604 and Senate Bill 28. These chapters, contingent on the enactment of a constitutional amendment, alter various provisions of the statutory collective bargaining process for state employees. Both chapters contain an identical version of the constitutional amendment language. As a result, the Attorney General's office has advised that both questions will have to appear on the ballot. So essentially, since both bills were enacted into law, the same identical language would be printed on the ballot as question 1 and question 2. In an effort to limit voter confusion and the possibility of one question passing and the other not, for example, essentially what these bills would do is it would repeal the constitutional language from Chapter 156. As a result, only the language that's contained in Chapter 155, the constitutional amendment language, will appear on the ballot, and it will appear on the ballot once as question 1. It does not make any other changes to either Chapter 155 or 156 for their statutory provisions or to the language on the ballot itself. So with that, we would ask you to give this legislation a favorable report. Thank you. I'll take any questions.
All right, thank you. Opening up for questions from members.
Okay, we're going to alternate between House and Senate, so who had a light up? Where is it? Okay, Senator Simon Ayer.
Yes, thank you. In the middle. It's a big one here. Just a quick question. You said this was going to go on the ballot. Is that correct?
Yes, it's scheduled for the ballot in November.
And I'm not familiar with the previous legislation, but is the text of the ballot question within the bill, or is that something determined by Secretary of State or who?
I believe in the bill itself, it says the question on the ballot should look substantially like this text. And I think the text that will appear on the ballot is very similar, if not identical, to what is included in the legislation.
And when you say substantial, who would interpret that to if they had to tweak it?
Yeah, essentially what we do in DLS is we prepare ballot question summaries that then go to the Attorney General's office that they review, and then it goes to the State Board of Elections. So everyone kind of ensures that it is reflective of what is supposed to be.
And that's normal process?
That's the regular normal process. That's
Okay.
correct.
Thank you.
Mm-hmm.
All right. right, seeing no more questions, that will conclude the bill hearing on HB 2101. Thank you very much, Mr. Bishop.
Okay, we're going to move next to House Bill 2100 and Senate Bill 2100 in anticipation of that bill. And I'm going to call up Senate President Bill Ferguson and Speaker of the House, Jocelyn Pena-Melnick. Okay, the ground rules, we're not going to time these two witnesses. After that, everybody subsequent will be on a 2-minute clock. We're going to take all the live in-person witnesses first, and then we're going to transition to the virtual witnesses after that. And those are basically the ground rules. And then we will, when we get to questions, we'll try to alternate between House members and Senate members. So with that, Mr. President, do you want to lead off, or do you have, between the two of you who would like to lead off, we'll leave it up to you two.
You can go ahead with history.
Thank you, Mr. Chair, Madam Chair. Pleasure to be with you and members of the joint committees. I have to say it is a bit intimidating with these large screens to have your head on the front. So I'm sorry for ruining everyone's view today. Not the speaker, who looks wonderful as always. It is a pleasure to be here with you all to present Senate Bills 2100 and House Bill 2100, again alongside Speaker Jocelyn Pena-Melnick. As many of you know, the General Assembly passed Senate Bill 1012 of 2022, which is our current congressional map. That map responded to a March 2022 Circuit Court order striking down the enacted 2021 congressional map and ordered the General Assembly to draw a new congressional map. In the court opinion striking down the 2021 congressional map in Schlega versus Lamone and Parrott versus Lamone, the Circuit Court for Anne Arundel County held that the districting standards in Article 3, Section 4 of the Maryland Constitution apply to congressional districts, though no Maryland constitutional provision expressly addresses congressional redistricting. As the Speaker will describe in more detail, this legislation clarifies the very long-standing understanding and case law that Article 3, Section 4 of the Maryland Constitution governs only General Assembly districting plans, not congressional districting plans. Senate Bill 2100 and House Bill 2100 will let Marylanders amend the state constitution to clarify the congressional districting standards here in our state. These bills are the responsible first step in ensuring that when Maryland draws a congressional map the next time, that it is acting from a position of clarity. Thank you, Chair Feldman and Chair Wells. I urge the committees to adopt a favorable committee report with amendment.
Okay, thank you, Mr. President, Madam Speaker, and we'll go to Majority Leader Moon. Are you testifying or just here for questions?
Just for questions, thank you.
Okay, so after Speaker testifies, then we'll open it up for Q&A. Madam Speaker.
Thank you very much and good afternoon. And I want to thank my counterpart, Senate President Ferguson. Thank you for working on this with me. So good afternoon, Chair Wells, Chair Feldman, Vice Chairs, and members of the committees. I'm pleased to join Senate President Ferguson in support of House Bill 2100 and Senate Bill 2100. President Ferguson has explained the history that brought us to this moment. I want to focus on what this legislation does and what it does not do. House Bill 2100 and Senate Bill 2100 do not contain a congressional map. It does not draw a single district line or make any changes ahead of the 2026 general election. It does not. This proposed constitutional amendment makes 3 straightforward changes to allow Maryland to meet the moment as states across the country engage in mid-decade redistricting. First, it clarifies that the term legislative district in Article 3 of the Maryland Constitution refers to districts for the Maryland Senate and the House of Delegates. This resolves any ambiguity and gives courts clear guidance going forward. Second, it clarifies that the Maryland Constitution and Declaration of Rights do not apply to a congressional districting plan. Therefore, in the event of a future lawsuit, courts will judge the constitutionality of the map ahead of the applicable federal law. Third, it gives the General Assembly the option to send a congressional redistricting case directly to the Supreme Court of Maryland when the time is critical. It is important to note that this does not change the process for every case. It simply places another tool in the toolbox to dispute, so that disputes can be resolved quickly and efficiently when necessary. We will also offer a narrow technical amendment, which you have already received in the reprint, that addresses the new ballot deadline. Because the special session began after the July 1st certification deadline and ends on the 90-day posting deadline, the amendment will allow election officials to place the question on the 2026 ballot. This technical change will not alter the substance of the legislation. It does not. It will simply reconcile the special session calendar with the ballot certification timeline. Across the country, states are considering and passing mid-decade congressional redistricting plans. Maryland cannot remain on the sidelines because of uncertainty in our own constitutional language. Other states should not be able to diminish the voices of Marylanders in Congress. Maryland is home to tens of thousands of federal employees, families who are struggling to afford health care, and communities who are afraid to leave their homes because federal immigration enforcement refuses to follow the Constitution. House Bill 2100 and Senate Bill 2100 offer clarity, offer parity, and preparedness. It clarifies the law. It ensures Maryland plays by the same set of rules as other states. It prepares for the future by giving the legislature the ability to quickly respond, if necessary, in state court as we navigate these unprecedented times. Ultimately, and this is very important, this question will be placed before the people, who will have the final say in November about how Maryland chooses to meet this moment, because every day Americans are being tested. And every day we see people answering these tests with unbelievable courage. We're not here because we want to be here, trust me. We're not. We're here because these times call for it. I believe that Maryland will meet that moment with clarity, resolve, and confidence. I respectfully request a favorable report on both bills. Thank you.
Okay, thank you, Speaker. Okay, we'll take questions at this point, starting on the Senate side of things. Start with Senator West, a visitor from the Judicial Proceedings Committee.
Thank you, Mr. Co-Chairman. I guess this question is for either of the two presenters. Section 4 of the U.S. Constitution reads in relevant part, "The United States shall guarantee to every state in the Union a Republican form of government." In Federalist Number 39, James Madison, who's generally credited as being the author of the Constitution, wrote, "We may define a republic to be a government which derives all its powers directly or indirectly from the great body of the people. It is essential," and in Federalist 39, Madison capitalized the word essential, all the letters of the word essential. "It is essential to such a government that it be derived from the great body of the society, not from a favored class of it." So my question is, do you agree that with Madison, that the definition of a republic is such that a government is not derived from a particular favored class of citizens?
I'm not sure that that has specific relevance to the constitutional amendment that we are discussing, but certainly appreciate the senator's rendition of it.
So if the effect of the proposed amendment to Maryland's Constitution is to enable, as a matter of law, a favored class of Maryland citizens, excluding the other citizens of the state, to elect all 8 congressmen representing Maryland, would you say that Maryland will remain a republic under the language of the U.S. Constitution?
I would say that we are set on ensuring that Maryland has free and fair elections.
I appreciate the answer. I'm not sure it answers the question. So if the effect of this amendment is to enable as a matter of law a particular favored class of Maryland citizens, excluding the others, to elect all 8 congressmen, do you think Maryland will remain a republic under the language of the U.S. Constitution?
Most certainly, because I don't think it is determined by a partisan outcome in an election, as in every election in a democracy that is free and fair, there are competing ideas and there is a winner and a loser. Nothing about this amendment addresses that.
So if the Constitution and laws of Maryland, including the statute setting forth the district lines for congressional districts, are changed so that a favored class of citizens, namely citizens who are registered as Democrats, will have the power to elect all 8 of Maryland's congressmen, and so that the other citizens of the state are effectively disenfranchised insofar as elections to Congress are concerned, would you not agree that in such an event, Maryland would no longer qualify as a republic?
Simply, Senator, I don't believe that a political party is a favored class of citizens. So I think the premise of the question is faulty.
Okay. Let me go on, if I could, Mr. Chair.
Okay.
Could I ask some more questions? Or
How about one more question? Other people the lights are popping up, so if you could ask one additional question.
Okay. Let me just ask one more question, and perhaps others will want to follow up to this. The Maryland Declaration of Rights was adopted in 1776. Our courts have repeatedly held that the Declaration of Rights is an integral part of Maryland's Constitution and is to be given equal weight by the courts as the state constitution. The bill before us today purports to amend the Maryland Declaration of Rights by stating that nothing in the Declaration of Rights provides applicable criteria for evaluating the constitutionality of congressional redistricting. In other words, in the event of future constitutional challenge to the gerrymandering of congressional districts, the provisions of the Declaration of Rights will be inapplicable. This represents a huge carve-out. Are you aware of any other time in the 250 years that the Declaration of Rights has set forth the inalienable rights of the citizens of Maryland that a similar bill has been introduced to eliminate certain of the rights accorded to the citizens of Maryland by the Declaration of Rights?
For the 200 years prior, the application of the Declaration of Rights was not valid on congressional mapmaking. When the Constitution was adopted and when subsequent constitutional conventions took place, in all cases, the reference to legislative districts was for state legislative districts. For the first time in Maryland history, in 2022, a district court judge sitting on behalf of the Supreme Court of Maryland interpreted that differently, not in a binding way and not that we believe is applicable. And so what was created was uncertainty because at every point prior to that, the Declaration of Rights were not applicable. And so that is what this amendment is to address and provide the same clarity that we had for the hundreds of years prior.
Of course, in 1776, when the Declaration of Rights was adopted, 12 years before the U.S. Constitution, there were only legislative elections in Maryland. There were no congressional districts in Maryland because there were no congressional districts anywhere. So is it your contention that when the Declaration of Rights used the word legislature, that they intended to exclude congressional elections from the effect of the Declaration of Rights?
It is my contention that subsequent constitutional conventions, which reaffirmed and the people of Maryland voted to affirm, maintained that standard, and that courts interpreted it that the legislative districts were state legislative districts up until 2022. Until that point, a non-binding opinion was provided that changed that clarification. This amendment clarifies to what it was again for hundreds of years prior.
Thank you for your answers to my questions.
Okay, we're going to go over to the House side. Chair Wells.
Yep. Delegate Fair.
Thank you, Madam Chair. Thank you, Madam Speaker, and to you and Mr. Majority Leader. A couple of quick questions just to clarify, and then I'd like to cut back to the Senator's questions there if we can. Is there any areas of our current Constitution that reference legislative districts outside of Article 3, Section 4? And do they specify?
The Article 3 right, which is the most compelling historical example, because it is the literal structure of the Maryland Constitution. And it actually referenced to the legislative department, right? It's specifically titled Legislative Department. Every single section surrounding Section 4 strictly dictates the parameters of the Maryland General Assembly. And then when you look at the surrounding sections, Section 2, it goes into the size of the General Assembly, right? 47 senators, 141 delegates. And then Section 3 commands how the state must be split into legislative districts, right? So it's still dealing with legislative districts. And then Section 5 details the governor's timeline for submitting a legislative redistricting plan. There's nothing in there about Congress.
So would we say that, that the jurisprudence from the Battaglia decision was kind of an outlier for how historically this constitutional provision has been looked at?
Yes, and I would argue that for decades, whenever citizens or political parties sue the state under Article 3, Section 4, over a lack of compactness or failure to respect political subdivisions, every single case exclusively targeted state house or state senate maps. Every single one of them.
And you mentioned something about parity with other states. Would it be fair to say that Maryland is the outlier here, that it's, with its congressional districts being up for judicial review in this way?
It is, absolutely.
Okay. There was a question made about the Federalist Papers, which I really appreciated from our senator, and I just wanted to cut into, and again, either yourself or Majority Leader Moon can weigh in on this, but has the Supreme Court weighed in on partisan redistricting? This is kind of off topic from the bill, but I just want to make sure we address that question.
Thank you for the question. Certainly, they have cleared the way, so to the extent there's any questions about whether we can stand as a republic form of government as discussed, certainly the Supreme Court believes that's the case. And to give a little more color to some of the history on this that's been alluded to by both the Senate President and the Speaker, it's not just that the legislative history on the term legislative district being only about state senate and delegate districts. It's not just that that's clear, because, as the Speaker noted, this ultimately goes before the voters. So have all of the other prior constitutional changes where they have touched these terms. And in the late 60s, the voters had before them language that would have created standards for both legislative and congressional redistricting, and they rejected it. They overwhelmingly rejected it and said no to it. And then in the 70s, just a few years later, they came back with language that was only about legislative districts, meaning state legislative districts. The legislative history about that is clear. The ballot language that was put before the voters is clear. And so if we were not to accept that history, we would be allowing a single judge, who's the errant judge in the decades we've had this interpretation of law, to upend the will of the voters that's been established decades ago in the 70s, but really since 1867.
So to make that absolutely crystal clear, the voters had the choice to create in the Constitution an area where we looked at congressional and legislative districts, and the voters chose no on that question.
For good or for bad, wherever you stand on the issue, the actual history of this, the voters said no to the inclusion of congressional districts in the 60s, and then when they came back in the 70s and touched the language again, all of the history says they're very clearly talking about state legislative districts.
Thank you, Mr. Majority Leader. Thank you, Madam Speaker.
Thank you.
Okay, let's go over to the Senate side. Senator Carrozza.
Thank you, Mr. Chair. I want to first, going back to the actual bill language and trying to understand a little bit about the new process that would be put in place. And given that the bill, in effect, eliminates existing rights from Maryland citizens to challenge congressional maps in any Maryland court going forward. But the bill at the same time creates a new authorization by the Maryland General Assembly to grant the Supreme Court jurisdiction on a case-by-case determination. At the same time, the bill states that the criteria of that districts be compact, that they apply at the state level. I'm trying to understand in the process when you would use this authority that to grant the Supreme Court the right to review the map, how that would work when you've taken out the criteria related to the congressional maps.
Thank you, Senator. As is a case in American jurisprudence, a litigant can bring any claim at any time in any court. That does not make it a valid claim, it does not make it a meritorious claim, but that right is afforded to any individual to bring a case forward. And so in the case that there is a future claim in a state court, that would be appealable. It would be directly, it would go directly to the Supreme Court of Maryland instead of having to wait for multiple levels of appeal on any basis. There are other times where Maryland state courts will interpret federal law alongside. I don't believe that in redistricting that's necessarily the case. But what it will always be available for Maryland state courts, I believe that is true. But there are Maryland courts, Maryland federal courts, that will still have the same maps will still be required to comply with the U.S. Constitution and with federal law, as is the case in the majority of other states who would be in this situation were Marylanders to approve this amendment.
Okay, but I think where it's causing confusion with our constituents, you are removing the citizen challenge of partisan gerrymandering to go to other courts. You have changed the bill and you're saying it would go to the Supreme Court. And yet, the Supreme Court would not have criteria to review, you've removed the criteria for the congressional maps. So therefore, you have a case where the Supreme Court, if they don't have the criteria to review, they would dismiss these cases. So in essence, you're taking away a citizen's right to challenge a partisan gerrymandered map. And so it's very confusing. You're changing the Constitution, you're taking out the criteria that are still applying to the state legislative districts, but not the congressional districts, and then you're giving this new authority that the Maryland General Assembly has. So since we are the Maryland General Assembly, I'm trying to better understand when that authority would be used, and the concern that because you've removed the criteria for congressional maps, the Supreme Court's going to dismiss those cases, and therefore citizens really don't have a fair voice in this process.
Thank you, Senator. If I have heard the question correctly, I think the issue comes down to what is the appropriate venue for which a Marylander could challenge a future map. And the issue is that this amendment would establish where Maryland had been, that the appropriate venue for challenging that map would be through federal standards, either through the U.S. Constitution or federal statute. And those cases are best brought through federal courts. In the case that someone opted to bring a claim in the state court, it would go immediately to the Supreme Court. I would imagine they would be advised to bring that challenge in a federal court moving forward, as is the case in the many other states that have this set up where their state constitutions do not apply to the federal map making, and was the case in Maryland for hundreds of years prior.
But you do acknowledge that the criteria that we have for the state legislative maps is removed for the congressional maps.
That is what this amendment would do, and the standards for map making have always been different between state maps and congressional maps. That has always been the case, particularly when we think about one person, one vote, where the federal maps go to one singular voter, has to be divided by one singular vote, or one singular individual. The state maps have a 5% in either direction because of the nature of having more districts to redistrict. So there have always been separate standards between the two. That was the case even with the 2022 opinion. So there is nothing foreign about that. That is not something different, that we would have different standards. We would just be aligning to how it has always been, and how, until the Battaglia opinion in 2022, the federal courts and federal standards were what governed congressional federal maps.
I just would respond that my constituents are very concerned when you remove any criterion safeguards. One follow-up question, Mr. Chair.
Okay, one follow-up, Senator Cruz.
I wanted to go back to Senator West was raising issues about the affected sections of the Declarations of Rights, which would be voided by this bill. Article 7 of the Declaration of Rights is known as the Free Elections Provision. It reads in relevant part that the right of the people to participate in the legislature is the best security of liberty and the foundation of all free government. For this purpose, elections ought to be free, end quote. In this provision, the term legislature has been interpreted by the courts to include both elections to the state legislature and congressional elections. The courts have also emphasized that the pivotal goal of the Free Elections Clause includes the protection of the right of political participation in congressional elections. Would you agree that this bill will amend the Declaration of Rights so as to deny to the citizens of Maryland any ability to challenge future congressional gerrymandering on the grounds that the actions of the General Assembly have violated the Free Elections Clause of the Declaration of Rights?
What the amendment would do, if Marylanders vote to approve it as part of our state constitution, would be to align Maryland standards with the requirements under the U.S. Constitution and federal law, as is the case with the many other states who have a very similarly situated set of criteria.
At the same time, removing the criteria for the congressional districts in this constitutional question.
It would restore how it had been. It would clarify that it has continued to be that way, that no law has changed for it to have been different, and that we would have clarity moving forward, that we would have the same laws in effect under the U.S. Constitution and federal law governing federal congressional redistricting here in the state of Maryland.
Well, most of my constituents aren't attorneys, and I'm still seeking that clarity. Thank you.
Okay.
Thank you.
Chair Wells?
Thank you. Delegate Chisholm?
Thank you, Madam Chair. Thank you all for being here, Mr. President, Madam Speaker, Mr. Majority Leader. I'm just trying to wrap my head around this almost like, you know, I peaked in school in 5th grade, so I'm going to break this down to the 5th grade level. Because I think this is very serious, though, because I think that most of the public was just said, you said we're going to bring clarity. How are we going to bring clarity? Like if I were to sit down with somebody and say, I want you to draw a map, but give them no guidelines, and if we pass this amendment, are you going to be able to draw a map any way you feel is going to solve the problems that you, Madam Speaker, brought out? People are living in fear, and you labeled several things. If we pass this, how do we solve those problems you're speaking of? And I know you're talking about following federal law in order to draw these maps. Does that then take into account the Kalea decision? And I'm just confused on how you're going to draw the map and what kind of map is going to solve the problems you're talking about if you could do it today. How are you drawing this map?
We're not talking about maps today. The
Well, that's why we're
legislation,
here.
the
This amendment-
legislation that you have today does not include any maps, does not say how the maps will be drawn. But what this legislation that you have today basically clarifies and basically codifies existing the practice that we have had for more than 150 years. Where the standard, when it came to Article 3, Section 4, was used for state maps. not for congressional maps.
So you're talking about maps.
Congressional lines, the laws to be followed was the federal law and the Voting Rights Act of 1965. The bill you have here basically says that the Battaglia decision was not proper. It wasn't right. It wasn't what we have done in the past. Because it's quite clear that Section 3, right? Article 4 deals with state law, the Maryland General Assembly and the districts. And that is what this bill does. We have no maps right here. I couldn't tell you how we're going to draw the maps because we haven't even decided whether we're going to draw the maps.
With all due respect, Madam Speaker, this is about maps.
With all due respect, this is about the standard. Today.
Two maps.
Today is about the standard that will be used, okay, for state maps and what will not be used for congressional maps. Very simple.
So when I go back to my constituents, I can say that they're going to draw maps based on federal law?
Correct.
And the U.S. Constitution.
And the U.S. Constitution.
And you feel like we've been breaking the U.S. Constitution up until this point?
I feel that the Battaglia decision was not correct, and that it's not the standard for us to follow, because it doesn't do it like we have done it in the past. It deviates from that standard.
So we were clear up until the last,
That is
the
correct.
Battaglia decision.
That is correct. In every single case that dealt with the state maps or suit.
Thank you, Madam Chair. Thank you.
Okay, let's go to Senator Washington next.
Oh, thank you. Thank you. Our leaders, our presiding officers, appreciate you being here today and appreciate this opportunity to speak. I want to first just address some of the questions. I want to ask you some questions about our Declaration of Rights. And in that first article, right, it says that all government of right originates with the people and is founded in compact only and instituted solely for the good of the whole. And here's the piece where I'd like you to respond, particularly in context of some of the challenges thus far. And they have, at all times, the inalienable right to alter, reform, or abolish their form of government in such manner as they deem expedient. And so form of government is not necessarily, would you say, the United States, but it's how power is distributed, how leaders are chosen, and at different levels does the state exert over society. So would you agree, or would you say that this adjustment of our state's constitution is in fact consistent with the first article of the Declaration, which says that it is the right to change and reform or abolish the form of government?
Ultimately, yes, yes, with the note that, within our Constitution, we believe that the court incorrectly interpreted in 2022 and are using the democratic tools that are outlined in the Constitution to address that lack of certainty and put it to the voters of Maryland to determine whether or not that clarity should be addressed by adopting a constitutional amendment.
And Madam Speaker, the courts don't make laws, is that correct? In other words,
We do.
we make the law.
That's correct.
So the court case that is being cited or referenced, would you agree, it seems as though there are some that are presenting to constituents that this is law, that the court case is law, when in fact it is not law. Would you agree?
It is not law, and what we're saying and what should be said to the constituents is that for over 150 years, when interpreting issues such as what we have in front of us, that was not the standard.
Mm-hmm. So clarifying that newly introduced that standard. And so specifically would you also agree that a statement that says there are no standards would be incorrect, because you did in fact say that the federal standards are population equality, right? Voting Rights Act, so that is still there. You know, and we still have work on this, but equal protections, of course. So those are currently the standards.
And they are the ones that have been used for many, 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 many years.
Yeah. And so therefore, on, I guess, page 2 of the bill, and it would be, you know, under Article 3, and it would be the Section 62, where it says, "Nothing in this article or elsewhere in this Constitution, including the Declaration of Rights, provides applicable criteria for the boundaries of a congressional district." This is this removing? This is not, it's the way I read, and would you agree that this is not removing any criteria? It's saying it's not there. That's how I read it. Would you agree that we're simply saying very clearly that nothing in this article or elsewhere should be considered, including the Declaration of Rights, as being applied to the Constitution? It's not taking away anything from the Declaration. It's just saying when you're looking for Maryland's laws around how to draw congressional lines, that they are not to be found exclusively or primarily in the Declaration of Rights or the Federalist Papers. Would that?
As was the case for hundreds of years prior to the 2022, and I believe I said district court, I was thinking federal district court, circuit, sitting as a circuit court judge, as a trier of fact, the 2022 case. That was the moment in which there was a new interpretation and a new application of the Declaration of the Constitution and the Declaration of Rights to congressional mapmaking. This is clarifying how it was for the hundreds of years prior, that it would be the U.S. Constitution and federal law that are the standards for congressional mapmaking moving forward, as they were previously.
And chairs, this is my final sort of question on this section. I'll return to some others. But could our presiding officers perhaps, I guess, reflect or respond to something that I seem to be hearing is the equation of political participation, or the conflation of political participation with political party. So, you know, earlier we were talking about factions. There was a sort of a statement about factions and a caution about factions. In fact, when the Federalist Papers were written, there weren't any, you know, parties per se. And ironically, interesting, the first party that was established was the Federalist Party. So even those who were writing this ended up being the ones to establish the first party. But do you believe, or is it your understanding that factions are to be interpreted to be a point of view or a position? That partisanship is not necessarily, I guess the question is, does partisanship equal political party? Or does partisanship could have a broader interpretation that could be considered by the courts or whoever? It is not exclusively related to political parties.
Think about the way. I would say there's a long history in the United States jurisprudence that political opinions are to be avoided by appellate courts. And so political questions are to be determined by political bodies under the structure of our republic and our democracy. And therefore, it is up to the legislature to decide, be it at the federal level or at a state level, what the appropriate political response to questions are for the state of our government moving forward.
And in the
Okay.
declaration and are consistent with Article 1, this is going before the voters
Correct.
ultimately. Thank you. Thank you, Mr.
Okay, thank you, Senator Washington. Chair Wells.
Thank you, Delegate Wilson.
Thank you, Madam Speaker. Senate President. Delegate Moon, this question's for you. Just briefly, you had touched on the legislative history, but I felt it important to kind of step back. We talked about in 1964, the Maryland committee had a Supreme Court case, the Maryland Committee versus Taws, correct? And in that decision was found that there was a malapportionment of state legislatures, focus on state legislatures, correct? They found it unconstitutional. And in fact, we had the 3/5 vote in the House, and we amended that bill in the 1967-68 Constitutional Convention, correct?
Yes.
And in that time, we put it to the people, and we included the same redistricting standards for both the congressional and legislative districts, correct?
Correct.
And that was voted down by the people, correct?
That is also correct.
Okay, and at that time, we still had a problem. So when we came back in 1970, at that point, after that was voted down, we created a framework for state legislative redistricting only, correct?
Yeah, this is the inconvenient part of the legislative history, that this has been affirmatively rejected by the voters in the past.
In this body, at that time, because we were being sued not for our congressional districts, but for our legislative malapportionment, correct?
Correct.
So at that time, this body, in 1970, we amended it to create different legislative districts, Senate and House. Unfortunately, there was some overlap in the senatorial versus delegate districts. But at that time, there was a constitutional amendment that was ratified by the voters of this state, correct?
Correct.
The laws we made, the constitutional amendment was ratified by the citizens.
Correct.
And unfortunately, because of issues, we realized that 2 years later, there's some of the districts that overlap, so we had to correct that. And so in 1972, I believe, 1972, that's when we corrected it. But I want to step back. So when we talked about this is going to go to a referendum, and I think it's Title VII of the election law requires that this question be prepared in clear and concise language, devoid of technical and legal terms, to the extent possible by the Department of Legislative Services and approved by the the Attorney General. And that was done in each of these times, including this one, correct?
That is correct.
And in 1972, again, when this body decided it was going to amend the Constitution to cure those overlapping districts, it was again addressing only the number of senators and the number of delegates. And each time the word legislative district was focused solely on the state legislative districts, correct?
Correct, and again, the ballot language referred to this being General Assembly districts. The Washington Post coverage and editorials referred to this being General Assembly districts. The entirety of the legislative discussion in Annapolis was squarely about General Assembly districts. And again, the voters had just years prior to this affirmatively rejected including congressional district boundaries standards in the state constitution. So you had it in both directions.
That's correct. So it's fair to say that if the interpretation that I hear from possibly some of my colleagues as well as the Judge Battaglia, if they were indeed correct, then the actual amendment that the voters voted on would have been deemed a violation of state election laws because it never mentions anything but legislative districts. There was no inference. In fact, you're not allowed to really infer because it says prepared in clear and concise language devoid of technical and legal terms. So when we put it to the citizens in 1969, 1970, and 1972, it was, again, as we said, the 69 was for congressional and legislative. That was rejected. 70 and 72, again, following our laws as tight as we could, this body decided that we were going to determine our legislative district redistricting only. And it was voted on by the citizens. This body approved by 3/5, and then our citizens also voted it in, correct?
Correct, and I would also add that in between all of this time, there have been multiple bills also introduced in the General Assembly that would have attempted to create independent congressional redistricting and other standards that were not taken up and passed by this body affirmatively.
So I say all that to say it seems like it's a little bit of I guess, confusion that there was ever any intent by this body except for 1969 to address congressional redistricting. And our citizens only had one time in 1969 to vote on that. And each other time, including this bill here, they're voting on legislative redistricting. And we're clarifying it almost for purposes, again, because it seems like our body has spoken multiple times. It seems like the citizens of this state have spoken multiple times that we're focusing on legislative redistricting in Article 3, Section 4, correct?
Correct, and I think it's pretty plain on its face that that's the case. We have things like 1, 2, 3 member districts for the assembly, just things that you just absolutely cannot apply to congressional elections the way they do their districts.
That is correct. And so it's my understanding that we're not fixing anything. The body has spoken. We're just clarifying it because there was some confusion. We have never abrogated, nor have we changed directions from the understanding that we are legislating legislative redistricting and that we're applying a separate standard, nor have we ever deviated, to my knowledge, from that since 1969 of addressing legislative districts and keeping them separate from congressional districts.
That's correct.
So it feels like, again, a lot of this is very specious reasoning for what not only our body has repeatedly stood up for and proposed, but for the citizens of Maryland, what they have repeatedly, as they will have another opportunity now to have their voice in saying that, yes, affirmatively, this is how we believe that we should be dealing with our congressional and legislative districts. Correct?
That's correct.
Thank you.
Thank you.
Okay, let's go to Senator Gallion.
Thank you, Mr. Chair. I'm a little confused now. Hopefully the panel can clear something up for me. I just heard that this is not about maps. I heard that a moment ago. But, Mr. President, you had a Facebook post out 17 hours ago. Under the Baltimore Promise part, it said, the wrong map could carve Baltimore up, splitting its neighborhoods across districts until the city loses its voice in Congress. Baltimore has to stay whole. How will this amendment keep Baltimore whole?
That would be for any future attempt. This is about the standards under which any specific map would be created. Moving forward, any congressional redistricting would require the same legislative process that is required for the current system, where a bill is introduced. It has to be passed by both bodies of the General Assembly. It has to be signed or vetoed or overridden. And so the process by which any congressional map moves forward in the short term or the long term would not change.
Okay, so I guess the post is kind of really about two different things then.
Two different issues.
My understanding was that, it's regarding what we're dealing with now, so I think it kind of blended together there. On to the next question. Can you, any member, could you please identify a single constitutional protection for Maryland voters that HB 2100 adds rather than removes?
I would say the amendment clarifies that the U.S. Constitution and federal law apply. That is, as we believe they continue to, and clarifies that moving forward, there is not uncertainty, should Maryland voters approve this constitutional change, as to what are the binding legal constraints on a congressional redistricting map.
So why should voters approve an amendment that many say only reduces safeguards?
I certainly would not characterize it the same way. I would say that it puts us on equal footing with certainty to other states that have this same structure. And so just as other states have not applied their state constitutions to their congressional maps, Maryland would be in the same place.
Okay, we've heard from proponents of this legislation that recent U.S. Supreme Court decisions weaken federal voting rights protections. So the question kind of following that same line, why would Maryland respond to that by eliminating its own constitutional safeguards? So in other words, what does a federal voting rights ruling have to do with removing Maryland's standards for compactness, contiguity, and political boundaries?
I think the question is why now, is what I hear the senator saying. Why now is that we have the single largest threat to our democracy that I think at any time in our history that is before us. And there is a responsibility to assess the state of the land and where things stand and ensure that Maryland has certainty and clarity for whatever option we as elected representatives, empowered by the people, choose to present moving forward. And so I think that is fundamentally the why now, because the legal landscape, through the Calais decision and through subsequent actions by some of our sister states, have created a scenario in which every state has to face this question. And what we need in Maryland is certainty and clarity about the rules so that we are in a position to respond in a way that best protects the 6.5 million Marylanders, no matter what happens.
Okay, so we've also heard multiple times about clarity, clarifications. So if supporters call HB 2100 a clarification, how is it merely a clarification when it declares that nothing in the Maryland Constitution provides criteria for congressional districts? So why not state plainly on the ballot that a yes vote removes the state constitutional redistricting standards?
Because we do not believe those state constitutional are binding legislative, or binding precedent. The Battaglia opinion, and I can speak to this from personal experience, having gone through it and traveled the state for 13 different hearings and followed every law, dotted every I, crossed every T until a new standard was presented by a circuit court judge as the trier of fact. What's important to note is that as that was happening in March of 2022, either side could have appealed and did not. And we passed the subsequent map in order to have clarity for the map that we have today. That map is not touched. There is nothing different from that period. But this was not a Supreme Court of Maryland decision. This was a trier of fact. And so while it may have probative value or influential, it is not a binding precedent. And so that's why there is clarity as to what are the binding rules. What this amendment provides is a binding framework for subsequent legislatures in the case that redistricting is done in its normal time or not, what the certainty around what the rules are for congressional districting moving forward.
Okay, as presiding officers in our General Assembly, as our leaders here, I think from my standpoint, there's a major concern that I would like for you to address. When the legislature loses something under the Constitution, like they did with the Battaglia ruling, is there a concern that you're starting a precedent that, okay, when the courts overrule something, we're just going to change the rules? So, for instance, when the Ravens kick off in September, they could have 500 yards total offense, and their opposition could have 100, but they could still lose a game. It'd be like changing the rules because we didn't like the result. Is there a concern that you're leading to setting a precedent on that with that example?
I would say it's not setting precedent. That is our form of government. That is how we function. That we are designed by, that is the fundamental design of our system, that through Marbury versus Madison, that is the fundamental structure of our government, is that the judiciary is charged with interpreting the laws, and when the people's representatives, the elected body, believes that that interpretation is incorrect, the structure of government is established in order for us to have elected representatives reinterpret by passing a new law. I would say that is fundamental and inherent to our system, our American system for hundreds of years. So that is what we do. And when the courts, we believe, get it incorrect, that is precisely why the legislature exists, to reinterpret by passing a new statute.
But it's not our job to interpret a law. That's the judicial. Isn't there a separation of powers kind of argument there that?
And they interpret, we enact. And I think that's the fundamental point here, is that I would say I strongly disagree with the opinion that Judge Battaglia published. I don't believe it has binding precedent. I do think it has influential. It is probative. It is not binding. And so this is a mechanism, this amendment would allow Marylanders to have a say that whether or not we should have certainty as to what rules govern congressional redistricting.
Okay, one final, Mr. Chair.
Final
if I
question.
could.
And if I may,
There's a
since you-
concern.
since you mentioned both of us.
Yes.
I think that I agree with what the Senate President stated, but I would add that what we're doing here is that we're clarifying, right? Clarifying a muddy legal interpretation made by the court. It is not that we want to change the law. And we're saying that if you look at the structural evidence, and you look at the Constitution, and you look at Article 3, Section 4, and you look at the surrounding sections, that they basically are relevant and only mentioned the legislative districts for the state. And then I would say that there's nothing at all in that section that mentions Congress. So what we're trying to do here is to say her interpretation was not correct. It was not based on the actual laws that we have used for over 150 years. When you looked at the 1969 case, Constitutional Amendment 1970, 1972, and that what she decided is not consistent with the interpretation and what was used in the past, the standard.
And one final thing, Mr. Chair, thank you. There's definitely a concern among,
This will be
members.
final.
That's, Mr. Chair, this is a citizen legislature. I left the farm to come here, and I appreciate the deference allowing me to ask some questions. And this is probably the most important issue we'll deal with maybe this whole term, so I appreciate that. There's a concern in the minority party, okay? Wasn't that long ago, it was 4-4 delegations, but I know we're not talking maps, even though we kind of are in a way. Now it's 7-1 after we've been through all that. There's a concern about what appears to be a push to just get rid of these minority party voices. So if this goes through, gets passed, most of these things, is when they go on the ballot, they're very hard to stop once they get there. It happens occasionally, but it's very hard to stop a ballot question. You all know that. Let's not play like we don't know what we're doing here. So what's to stop, this worked so well this time, what's to stop the supermajority from coming back in another not-so-special session in the future and changing the state law rules? So, that you won't have all these pesky Republicans up here asking these tough questions. You could cut it back to 40-7 or whatever number. What's going to stop? Where does this train stop? And where do we stop worrying so much about what's going on at the federal level and worry about doing the right thing in Maryland?
Senator, I would say fundamentally that authority exists at all times and is not utilized because the elected members of this body in both chambers believe in the importance of every person's voice. And so that's why this is going to the ballot. I would say there have been ballot questions that have been rejected. That is certainly a possibility that could happen here. If the people of Maryland determine that not to be the case and move it forward, then that would, from my perspective, clarify the rules of the road for congressional redistricting moving forward. But I would also posit that at some point the fever will have to break, and Maryland has to be in a place to have options so that eventually the fever will break nationally as to where things stand.
All right, Delegate Fisher.
Thank you, Madam Chairwoman. Appreciate it. For any of you, have any districts, congressional districts, drawn so far in Maryland that currently exist, been drawn based on race? It's a pretty simple question. You draw them, you're the majority party, so you should have an answer.
There's one district, I wouldn't say based on the way you're interpreting it, but there's District 47. I think it's 47,
Congressional, I'm
B.
sorry.
Not congressional,
Congressional.
legislative, but not congressional that I know of.
Okay. So District 7 wasn't drawn for the purpose of race, making sure that an individual who is black was elected?
I believe that all districts were, there were multiple factors for all districts that were utilized in creation of maps that had a variety of factors of communities of interest, including social, economic, and similar communities were represented through the congressional maps. But it was multiple factors.
But that was one of them.
I would say that it was not a driving factor. I think that there were many other factors that were utilized. And I would say,
You said many other, which means that was one of them.
I would say that any socioeconomic demographic factor was, as in any survey data that is used, there is data available that demonstrates the variety of characteristics that make up the individuals within each congressional district.
Thank you. So House Bill 2100 creates one standard for state legislative districts that does not apply to congressional districts. More specifically, it states that the state Senate and House of Delegates districts shall consist of adjoining territory, be compact in form, and of substantially equal population. Due regard shall be given to natural boundaries and the boundaries of political subdivisions. What was the purpose of creating two standards in the state's constitution? Who does that? Why wouldn't you have the same standard apply to congressional districts?
Because we have never used Article 3, Section 4 is for congressional redistricting. We have never done that.
So if race is not a predominant factor in creating congressional district maps, like in D7 and D4, then why did you remove, and why are you removing that language specifically for congressional districts and keeping it in for state legislative districts?
Again, because history has shown, and the structural evidence, the way it's drafted, the Constitution, when you look at Article 3, Section 4, that it only deals with legislative districts. Congressional districts have followed federal law and the 1965 voting rights. And the 1965 voting rights, when it was whole, because we know that the Supreme Court has actually gotten rid of it, it used to allow for majority-minority districts to be created.
So Senate Bill 255, and this is related to House Bill 2100, which was forced through session the very last day, basically has, it talks about protected classes for elected officials at the local level. So why push that through if that's not your intent for congressional districts at the federal level? I just don't understand. We have all these different standards. It's like there's a standard at the local level, which is different than the standard at the state level, which is different than the standard at the federal level. And I just think it would be a principled thing for the majority party to do is to create one standard now that you're changing the Constitution.
Senate Bill 265 was
250
actually...
Senate Bill 255,
Senate Bill
sorry.
265, correct? Last session.
255.
255 was actually introduced in response to what the Supreme Court did to the Voting Rights Act.
Right, so
Okay,
250.
because we're able to control local elections, right? And that is the reason why that bill was put in place. Now, what we're saying is that I disagree with respectfully the way you're phrasing it, because what we're saying is that this bill that you have here, 2100, deals with the standards to be applied when drawing maps in the future, and that they should only apply to state districts, the legislative districts, because that is what we have done for more than 150 years. It is what the case law shows. It is also the different questions put forward, constitutional amendments in 1969, 1970, and 1972. What we're saying is that the requirements and standard for congressional maps should be what has always been used, which is federal law and the Voting Rights Act.
So, Madam Speaker or Senate President, the concern, there are many of them obviously, but one of the most obvious one is the majority party in Maryland draws the state legislative districts, correct?
I would say the governor introduces a resolution each year, or each decade at redistricting. So it is the governor's resolution.
This is an easy question. Clearly, you guys are the ones that control the state legislative district redistricting. So when you do that, and then you gerrymander those districts, it becomes eminently easier to get 3/5 of the state legislature in your party to push through a constitutional amendment, which is where we are today. And I guess my question is now that you've wrecked the republic by creating these districts that are very gerrymandered. Everybody agrees the state legislature is gerrymandered. You have 3-member districts in the state legislature, you have 2 and you have 1. And some are based on race and some are based on trying to marginalize Republicans. And the question is there any effort to try to fix that in this bill, House Bill 2100, where you're messing around with the state's constitution to create different standards for different races, while at the same time you would have an opportunity of, I don't know, putting redistricting in an independent commission so we don't have a rigged game, which is what we have, and everybody agrees it's rigged. That's a question.
So first of all, when the governor puts forward the plan and it comes to us, we have a process, right, where people can come and we have hearings and they can opine, give their opinion, and then we decide. That is correct. But
Majority
after
party
we
decides.
after we have a hearing, okay? And that is the way the process works and how we get it done here for any issue.
So the answer is there's no intent of creating an independent commission in Maryland for redistricting.
I would say.
For once in a while, to get rid of the rigged game that you guys are part of and have created.
And I can tell you that it's not you guys, because as I sit here.
You're in charge.
And I'm going to speak for myself, if I may.
Of course.
I am on record as being a co-sponsor twice of 2 Republican bills to create an independent commission. Jocelyn Peña-Melnick has done that, okay? However, it is very difficult for us to unilaterally disarm ourselves when the rest of the country is not doing it. There is presently a bill in Congress introduced by a Republican to create a federal commission, which will be the answer, but the Republican leadership is not taking it out.
So we don't control what happens in Congress. We only control what happens here. And so, a principled response would be.
It's all related.
We're in charge, and we have the ability to fix Maryland so that we have an actual 2-party system.
Again, it's all related.
I appreciate the dialogue as always. I do.
Absolutely.
And I appreciate it. Thank you. Thank you,
Thank
Mr.
you.
Chairman and Madam Chairman.
Okay, I'm going to go to Senator Simon Ayer next.
Thank you. It's always a pleasure. I thought I was done. I said my farewell speech and I was out of here. But at least we got called back for a good thing. Maybe. Anyway, Madam Speaker, since you're the sponsor of this bill, I'm going to direct the questions to you. But first, I want to put out the overarching issue is the people of Maryland. We're talking technicalities and legal language and so forth, and I will get to some of those questions. But we have seen in this body, in both bodies, where maps have been put forward to get the goal of 8-0 Democrat to Republican congressional seats. Matter of fact, it actually passed, and the courts overturned it, and of course, I'm sure you didn't like that. And we're here basically to remove it so the courts can never do that again. So when you have 8-0, what that basically does is it disenfranchises and suppresses approximately 3.5 million registered voters, all Republicans, because they don't vote in your primaries, all unaffiliated, because they don't vote in your primaries, and then all the Democrats who don't vote in the primaries. And that comes out to about 3.5 million people. And you say, well, maybe they'll change if we do this. We already have gerrymandered maps, and the Democrats don't come out in those races. So we are effectively suppressing 80% of the vote, so 20% can approve these 8-0 maps. So first, I had just a couple simple questions just to see how this relates to the bill, Madam Speaker. First, a very simple question.
Actually, it's okay. We had an agreement that the Senate will ask the Senate President would answer. That's why we've been doing this way. The senator's question, and I would answer to my House.
Interesting.
Because this is a joint hearing, but it's two separate hearings.
It's
But
your
let's
bill,
go
though,
with
right?
it. Yeah,
It's
it's
the
both
House
the
bills.
bills,
Both
Senate
bills.
Bill 2100 and House Bill 2100 are both in front of you right now.
I wish we would have had separate hearings, so the Senate could have asked questions on our bill and done this instead of having a joint rush through
But
this.
you could do it today. You're asking the questions.
Yes, thank
Yeah.
you. Okay, so the question, so the Speaker doesn't want to answer my question, so we'll direct it to.
I would go ahead and do it. We'll both answer it.
All right, Madam Speaker, do you support partisan gerrymandering?
Do I support partisan gerrymandering? No.
Okay. Secondly, do you support clear and plain language on a ballot question so the average citizen who's voting can understand it?
And I would tell you that I do, and if you look at the bill, page number 3, and if you look at line 10, it says the proposed constitutional amendment clarifies that certain standards in the Maryland Constitution apply only to districts used to elect members of the General Assembly. Pretty simple so far. Authorizes the General Assembly to grant original jurisdiction to the Supreme Court of Maryland to review the congressional districting plan of the state. That's pretty simple. And requires the criteria for boundaries of congressional districts to be determined by applicable federal law. That's pretty simple.
Okay, thank you. And to be honest with you and fair, if I wasn't sitting here up in the Senate and I went to the poll, I would probably vote for this constitutional amendment based on that wording, because it sounds really great. But you had
Just,
also
Senator, just to be
said,
clear, I believe this is current, it is affirming what the current standard has always been until a circuit court opinion that is not, that does not have binding precedent was authored in 2022. So this is affirming the current status, although there is uncertainty because of a circuit court opinion.
okay, and we'll get back to the actual language. Now, I've been listening to the other questions, and it said that for partisan gerrymandering, if this bill passes, we can take that to the federal court. Is that correct, Madam Chair? Speaker?
The bill states that we could go to Supreme Court, the Supreme Court. That's what the bill states. Maryland
Right.
Supreme Court.
I think they were talking about venues, because I think that we established that if somebody came today, or after this bill is approved, if a citizen came and took it to the Supreme Court, they would have no boundary criteria based on this bill removing that boundary criteria, so they would dismiss it. And the comment was, well, you still have the federal protections, and you could take it to federal court. Is that not true?
That is.
That's
know
true.
you-
I would
that
say
is
that's true.
Yep.
They
Okay.
can bring it in federal court.
So,
But if I
So-
may, the bill
Sure.
here doesn't necessarily say that it's in every case that it will go to the Supreme Court. If
Correct.
you look at the first page, line 23, it's actually, it is, and where is that section? It's actually page 2, line 20. It says, "The General Assembly shall have the power to grant original jurisdiction to the Supreme Court of Maryland to review the congressional district plan of the state." But it's not in every instance, okay? It was envisioned when time is critical, right? And time is of the essence, and you don't have a lot of time at all. But it doesn't take the rights away from anyone.
right, somebody, as Senate President said, anybody can bring a lawsuit. But when it's put on their desk, they're going to look at this bill if it passes and it's approved, and they'll say, we have no criteria to judge your challenge, and basically dismiss it. And then
Under these very specified situations, yes.
Sure, partisan gerrymandering.
Anything that is in the Declaration of Rights under the state constitution, as it was not applied previously, would not be applied in the future.
So you agree that a citizen could not bring an effective challenge to a partisan gerrymandered map to a U.S. Supreme, or Maryland Supreme Court?
Under what authority? I mean, I think that's the question, is under which authority? And if the basis of the claim is under the Declaration of Rights, and Marylanders have adopted this amendment, in that case, that is correct.
I'm
That
saying,
would not be it.
give me any case they could bring a partisan gerrymandered map.
Lawyers are creative. That's what happens.
That's not really an answer.
I mean, it is. There are state laws, and there are other, I mean,
Do you
There
have
are-
any concrete ways a citizen could bring a challenge for a gerrymandered map in our state courts?
Not
if
under the
this-
Declaration of Rights if a Marylanders adopt this
Okay.
amendment.
So, Madam Speaker, back to you. So we're talking about venues, so we could take this to the federal courts, and we could, have our citizens feel like have a voice in partisan gerrymandering. The only question I have on that is, are you familiar with Ruchu versus Common Cause?
No, go ahead.
So it basically says the federal court said they are not going to judge on partisan gerrymandering, but put it back to the states. So now, when we go to the federal court, they're going to say, we can't take this case. Take it back to your court, or the state court. Well, with this bill, it says we're taking all those criteria out. Sorry, you can't bring it here either. So we have taken that complete challenge off our plate effectively with this bill. And I understand you're saying, well, we thought this and this and this, but that is the effect, that no citizen will be able to challenge a gerrymandered partisan map in federal court and now in state court, unless you can tell me a concrete way we can.
I would say that the question is under what basis the challenge is being brought.
Partisan gerrymandering is the basis.
Senator, that is an outcome, not the basis of the claim. And so that is an output of a process. And so there is any number of challenges that would still be available to imaginary state X could violate a process that leads to a partisan map that would be a valid challenge.
Right.
That
I'm
is
not
still,
talking about the process. I'm talking about the boundary
but
criteria.
Senator, that's the answer to the question, is that fundamentally, it is how a claim is brought is the question I believe the senator is asking. Under what authority is the claim
What
being brought?
statute? Right?
Yeah, what is being violated?
What law,
So
what
if
is
a-
being violated?
If a person says the Democrat leadership has created an 8-0 map for the sole purpose of political advantage of advancing them and making these maps, can I bring that to the state court and say their boundaries were created for political purposes and I would like to challenge that?
Yes, but not under the Declaration of Rights. Under additional, if there were another Maryland statute, potentially, that would take consultation. But I would say what this U.S. Supreme Court has said is that that is a political question that this Supreme Court has refused to engage in. That does not mean if there is a subsequent Supreme Court that has a different interpretation
That's right.
of the same statutes. And so I think what is possible moving forward, particularly after the Calais opinion, is that you are going to see a significant number of cases brought for any number of reasons around redistricting, around voting rights, around access to the ballot, and there are going to be different interpretations that are going to clarify, or at least
Right, and I understand all that side stuff. What I'm talking about is partisan political gerrymandering. And the language in here says, nothing in this article or elsewhere in the Constitution, including the Declaration of Rights, provides applicable criteria for the boundaries of congressional districts. So if I came and said, we just passed this bill and it did it for partisan reasons, federal court would say, take it back to your state to look at it. This is directing the judges to say you cannot use criteria for boundary making to overturn. And I think that's the whole intent. I mean, we can talk about this, but, I mean, reality is I look at things simple. Legislature passed a bill, went 8-0. The courts overturned it, legislature didn't like it, now we're back with a constitutional amendment that says, no, you can't do that, and you'll never be able to do that again. So moving on to my next question.
just to clarify, not never you'll be able to do any of it. At any subsequent convening of the legislature, a new amendment could be proposed, passed, and approved by the people. So
Sure. I mean,
we are, but this, I think, Senator, is an important point.
we have to look at today. We can't talk about future
I
and
think
what
that's
they're gonna
exactly
do.
right, Senator. I think this is exactly where we are. I think this is the most important point of this entire experience, is that we are in a fundamentally different time for the state of American democracy. And this is why right now it is most important to assess where exactly do we stand and under what rules. Because there are questions that decades from now we are going to be answering in these next 18 months. And I think this is a very real moment where we have to ask ourselves, What exactly is the right standard for the state, and how are we existing in relationship to our sister and brother states? That is a very real state of American democracy that I think underpins this entire debate, that we can't, it's the elephant in the room that it is unbelievably important for the future of civil society. Can we exist together under what rules? It's why the good senator to the senators left mentioned the Article 1 of the Declaration of Rights. We are in a fundamental question of who represents who. What does this look like moving forward? And I believe that it is critical and essential for the state of Maryland to be in a place to help break the fever so that we do not find ourselves down this long-term path that we seem to be headed.
And if I may add, you made a statement that that they wouldn't have any other course of action. And I would disagree. I would say that they have an equal protection claim. They have a 14th Amendment as well. They have a First Amendment claim as well.
I didn't say that. I just said partisan politics. I didn't say. I agree that federal has other laws that will do that, but not for partisan gerrymandering.
But-
Hey, Senator Sotomayor, could I
It's
just
okay.
say, how many,
It's First Amendment, but we're going to disagree.
how many additional questions? We're trying to figure out some logistics here. So,
Shouldn't be too much longer, 10
Well-
minutes probably.
how about, come
Look,
on.
I've been down here 20 years. This is the biggest bill we've had. I think we can spend 10 minutes. If it was that important, we could have had separate hearings.
Okay, just for everybody, so what I think, in consultation with my co-chair, so after Senator Simonaire, I think the three folks who have, House members who have lights, and then the final senator will be one question from Senator Carrozza. So we'll go Simonaire, three House members, and then the final witness will be, senator with questions will be Senator Carrozza with one question. And with that, Senator Simonaire, why don't you
Sure, thank you.
proceed?
And it keeps coming back to the people. I mean, we're arguing as politicians and making our points, but this bill disenfranchises 3.5 million people, and that's what really burns me. You know, I understand party politics and all that, but that's really what gets me. And just, I hear this narrative, you know, the Trump administration's doing this and democracy's under threat and so forth. Let me remind the body that in 2021, this body passed an 8-0 map, fully gerrymandered, and guess who was in office? President Biden. There was no threat to democracy. So we can hide behind the veil of Trump, but this was occurring well before. It goes back to 2000, when it was a 4-4 Republican-Democrat, then it went 6-2, then it went 7-1, then it went 8-0, and it was overturned. This bill puts gerrymandering on steroids. Now, just the last point I had was about the ballot question. So, first of all, I have to ask about this amendment, because we just got this amendment.
Senator, just for I think it's important to clarify. This bill puts us in the exact same legal stature as we were 20 years ago, 25 years ago, when the map was 4-4.
That's debatable, but thank you. The amendment that was just offered, we had a bill before us, it was 2101. And they said, you know, this was a ballot initiative and they had language in there. And I asked him, I said, is that standard language? He said, yes, that's so we have somebody else looking at the language, make sure it's actually what the bill is doing. It's a check and balance. This amendment is striking that check and balance. It is striking at the general election a question substantially similar to the following. So this amendment says, we don't want you to check it. We're putting it in this bill, and that's what it's going to be. So my question is, if you want clear and plain language, why would you strike that to have somebody whose job it is to review?
Senator, it is substantially similar. So it is not a word for word. It is a substantially similar. In order to make sure that it is plain language, I would contend that this is very clear language.
That wasn't my question. I'm saying, why are you striking? What this amendment says is you can't touch this language.
It says
That's
that it
what
must
that
be
amendment does. It says
substantially
you
similar. I would say it does not say that expressly. It does not. If it said that, it would say it. It says that it must be substantially similar. So it
Right,
could
which implies that we can tweak it some to make sure that we have everything correct. Why are you putting this amendment in there?
It is how these bills are drafted.
That's not correct, Madam
It
Speaker.
is-
I just talked to the person before, and he says this is the standard language, and this amendment takes out the standard language. So I'm asking, why would you want to take that out?
I believe the prior language, I believe the prior bill also had ballot language within it.
Absolutely.
Right, and they said they used this language that you're striking. That's why I asked the question in the last bill hearing. So we can get offline and talk about that, that's fine.
What are we striking? Tell me
On
where in the
line
bill.
7, on page 3, you're striking, "At the general election, a question substantially similar to the following." So basically, you're putting forward language, and this is said, the language says, we have to put it basically what you're saying, but we can tweak it.
But
So
it's similar, right? Because
Right.
by the time this is reviewed, the bills go through a lot of reviews. The
I
AG's
agree.
office reviews it.
But you're
and
striking it.
It's basically line 9 to 18.
Right, that's the
Right?
language, whoever drafted this put that language in.
Right.
And there's a little caveat that as long as it's similar, they can tweak it.
Yes.
And this amendment says, no, you can't tweak it.
Just to clarify, that we did get a reprint right before we walked in here to make some, if somebody could give.
Yeah, there's a House amendment.
Oh, so the numbers may be off the moment.
Okay.
Yeah, you may
So
not
I
have.
don't
We
have,
can
I don't
swap
have that bill.
offline. I don't want to
Okay.
belabor that point. So to the bill language itself, the bill removes congressional maps from the requiring the compact adjoining territory to be, et cetera, due to the natural boundaries, et cetera. But the ballot question, instead of focusing on what you're taking away, the ballot question focuses on the General Assemblies, which we aren't changing. But the language instead, it's not saying anything about the Congress. So the effect of what we're doing is saying we're taking away this criteria from the congressional members, but we're going to present it to the public that we're just clarifying the General Assembly members who have nothing changed by this bill. So why are you focusing on the part that we're not changing, which sounds very good, opposed to what you're actually doing in the bill by saying Congress maps will no longer be compact, blah, 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 blah?
If I may, I would respectfully state that we are not taking away anything. We are saying that that was never the criteria for congressional maps. We're saying that if you look at the legislative history, that there's nothing in the legislative history for more than 150 years that indicate that this was the criteria for those maps. In addition, we're saying that if you look at Article 3, Section 4, that everything that is in there is relevant and the language used, Maryland General Assembly.
No, I understand all the
So I'm working for the assumption
surrounding.
that we're not taking away, we're clarifying, in my view, we're clarifying that this is a standard use for legislative map and that it was never to be applied for congressional maps.
So if somebody comes off the street, we go out there, and I read the ballot portion, it says, "The proposed constitutional amendment clarifies that certain standards of the Maryland Constitution apply only to districts used by the members of the General Assembly." Do you think they would have a clue we're talking about congressional maps?
Yes.
Especially after two phrases later that says
Yeah.
that the boundaries of congressional districts will be
Yes.
determined by applicable federal laws.
Absolutely.
Yes, well, we can agree to disagree that. So you're basically putting in there something that we're, regarding the General Assembly members, that we're not changing at all. That stays 100% exact. The congressional maps or members are not going to have those same criteria, but we're not going to mention that in the question. The second part, the bill removes the rights of citizens to effectively challenge any partisan gerrymandering on those grounds in our Constitution or Bill of Rights here. And what we have here in the language, it says, authorizes the General Assembly to grant original jurisdiction to the Supreme Court of Maryland to review the congressional district maps in the state. Basically, an average citizen would imply, oh, that's great, we're giving more judicial review, instead of saying that you basically can't bring any gerrymandered maps forward. And then the final point, the bill removes all partisan gerrymandering protections from the state of the Maryland Constitution. And it basically says, well, I'll read it. The criteria for boundaries of congressional districts to be determined of applicable federal laws. And when you have gerrymandered partisan maps, you can't go to federal law because they'll put them right back to the state. And this bill says, sorry, we don't have any criteria, you're out of luck. And so for my thing would you be willing to work on a bipartisan way that we could work to tweak this language that other people would feel more comfortable showing what this does. Just asking for a little consideration.
I feel totally comfortable with this language because I think it affirms current law. I think this is the fundamental point. There is one opinion in the last 150 years that is not of binding precedential value. It is probative, it is influential as a singular judge sitting on behalf of the Supreme Court that had, for the first time ever, applied a different standard. I would say today, that is not settled law. In fact, I would say the settled law is what this says in front of us, and what we are clarifying, that the existing law is clear that federal laws apply to federal maps, the state constitution applies to the state maps. That is not something that is new, and it's why I believe that this language affirms existing law absent a court that has probative value in a different interpretation.
And I give you credit. You are a smart lawyer, and you know your stuff. I will give you that credit. But everybody on the street doesn't have the history that you have on all this background. So I'm just asking if we can work together in a bipartisan manner, not on changing the substance of your bill, but just on the language itself. You're not open to any bipartisan work on that?
I don't believe that there needs to be clarification on the language, but most importantly, this is going to the voters of Maryland. I think the next 6 months, when's November? 5 months?
Yes.
Where are we, August? I don't even. Over the next 4 months,
Yeah.
there will be, I would imagine, an active campaign about this issue, that I respect the intelligence and thoughtfulness of Maryland voters, that this issue will be before them, and there will be lots of voices opining as to whether or not they should vote yes or no. And I suspect that is the appropriate place, and why it is best settled as a political question to be put to the voters of Maryland, as opposed to it simply by a single judge sitting on behalf of the Supreme Court in a circuit court.
I think it shows that there's no willingness on bipartisan on this effort. But we'll take it out to the public. Thank you.
Okay, Chair Wells, why don't we'll go with the
Thank you.
three House members, and then we'll close with the one
Okay.
question from Senator
So
Caruso.
our three, just so folks know, we'll go next with Delegate Tomlinson, Delegate Stewart, and then we will allow Delegate Chisholm to have another bite at the apple.
Thank you, Madam Chair. Madam Speaker, good afternoon.
Good afternoon. How are you?
I'm good. So I understand, obviously, this bill does not include a map. I think we've talked enough about that. But earlier in the Senate President's opening remarks, and I'm paraphrasing here, he'd said that the proposed constitutional amendment, that it would have an impact on redistricting whenever that happens next. So are we saying here that the intent of the bill is not to redistrict prior to the 2028 election cycle?
There's no, I don't think that that's what he meant. And actually, he's sitting right next to me, so can we say, can we ask him what he meant?
I think this proposed amendment clarifies for whatever, in the short term or long term, the next redistricting would happen. That in any subsequent map, that there would be clear rules as to what the state of the law is.
Gotcha. And sorry, I was just trying to follow
No, it's okay. It's all right.
Anybody can answer.
I just want him to speak for himself.
And then I had another question about the language in the bill. So page 2, lines 1 through 4. So it's the preamble. I understand it's not the actual, the actual language that will go into, that will be codified. But so page 2, lines 1 through 4, it says, whereas preserving Maryland's cohesive communities of interest connected by shared civic, social, economic, political subdivisions, and other common interests without unnecessary fragmentation is a legitimate neutral consideration in congressional redistricting. So it's the 3 words of without unnecessary fragmentation that I'm kind of stuck on. In your opinion, this could be for anybody, in your opinion, will there be moments in the future where fragmentation is considered necessary?
Whenever you draw a line, something is fragmented. And so I think that's an important consideration, that in any map, state, congressional, whatever, once a line is drawn, something is fragmented between two sides. And so I think there is always a matter of fragmentation. The question is whether there's unnecessary. And I believe it would be a bipartisan basis that we would say that communities of interest should be coherent wherever possible. I think that would be an objective that we should all want to see happen moving forward. And so I think that's really what we're getting at there.
Okay. And is there
And
any?
if I may,
oh, sorry.
the key word here is that on line 3, after you have unnecessary fragmentation, is a legitimate neutral consideration. So it's consideration, which means that it will be considered, right? It's not a mandate, right? Just to, for the record.
Okay. Thank you, Madam Chair.
Thank you, Delegate Stewart.
Thank you, Madam Chair. Great to see all three of you. Thanks for bringing this bill. Thanks for convening us here. I want to say for the record that I like being in this nice fancy room with the senators across the street who I don't get to see very much. A couple questions for the Majority Leader, if I could. Mr. Majority Leader,
He
just
was
to
feeling left out.
I know, he looked a little bored over there. So just to clarify, just kidding, Mr. Majority, you always look locked in. Just to clarify the legal background a little bit. In Olson versus O'Malley from 2012, a federal court examined Maryland's constitutional text and precedent, and that court concluded that Article 3, Section 4 applies to only the General Assembly districts, not the congressional districts. Is that true? Do I have that right?
That is true.
That is, oh, yeah, sorry.
Sorry, go ahead. Go ahead.
That is correct.
Go ahead. Okay. And so Judge Battaglia and the Shalega decision later reached a different conclusion. But is it true that that circuit court decision was never reviewed by any other court?
That is true, and subsequent court decisions have conflicted with that decision.
And in fact, isn't it true that when the state Supreme Court reviewed the legislative maps in that same year, in dicta, it seemed to suggest that it believed that the Shalega decision was incorrect?
You could argue there was a conflict there, yes.
And so isn't this bill and this amendment ultimately asking Maryland voters to resolve a genuine uncertainty about Maryland law rather than picking sides or overturning a precedent?
Yes, and again, it's an uncertainty that should have been settled by the voters themselves in the 60s. So we are preventing those voters from having their past decision being overturned by one judge.
And turning to the question of why now, which a few folks from mostly the Senate, but I guess from both sides have raised, is it true that on April 29th, the U.S. Supreme Court's decision in Louisiana versus Calais significantly narrowed the decision? Some have even said completely gutted the protections that men and women across this country died for that were afforded by Section 2 of the Voting Rights Act.
Severely narrowed the circumstances where that law might apply.
And since that decision came out, is it true that Louisiana, Tennessee, my home state of Alabama, and other states have moved rapidly to reconsider their maps as well?
Yes, I've got a little table of multiple states now that have already initiated their own maps and discussions and initial legislative interest for more to come in the next year or two.
And how could Maryland possibly operate on equal footing with all of these other states who are acting upon under established rules while we face significant uncertainty about even which provisions of our Constitution apply to which maps?
That's correct. We would be putting ourselves, well, the current status quo is that we are equal to Texas, Florida, what have you, with respect to congressional redistricting powers, again, subject to this one judge's misinterpretation. So yes, this would be restoring the status quo that Maryland does in fact have the same powers as all those other states.
All right, thank you guys.
Thank you, Delegate Chisholm.
Thank you, Madam Chair, and I'll just ask a quick yes or no question. I think we would all agree that Governor Moore has been one of the major drivers behind that. Would we agree on that, on this amendment?
I would say that's immaterial to me.
Well, let's just talk about his executive order. His executive order says this session is needed, and he called it special session, because the Voting Rights Act has been dismantled, which was just mentioned, and black representation has been diluted. Would you say that's the majority's reason for being here, or are you completely separate from what the governor has called for?
I cannot control, and I was not part of the drafting of the executive order. An executive order, as you know, is needed to bring us here, so he had to issue it. Whatever wording he used, that's up to him. I am here because I want to clarify in our caucus the standard that is used, because it is not the standard that has been used for 150 years, the court case in 2022, basically muddy the waters.
So you disagree with the motive of why the governor
It's
believes we're
not that I
here?
disagree, I'm telling you what my motive is. I can't speak for his motive, just like 10 minutes ago, he could do whatever he wants to do, the Senate President to go ahead and speak for himself. I can just speak for me. And for me, I feel that the interpretation of Judge Battaglia was incorrect, that Article 3, Section 4 does not mention at all congressional redistricting, that if we look at the case law, and if I may add, I think there was a case called In Red Legislative Districting of the State in 2002, where the Supreme Court of Maryland threw out Governor Paris Glendenning's state legislative map because it crossed the Chesapeake Bay and ignored the county lines, violating Article 3, Section 4. However, the state's non-compact congressional map for that exact same cycle was left untouched by the state courts. So when I looked at those cases in the 2012, and I looked at the 1965 Constitutional Amendment 69, 70, 72, and then I looked at the history, legislative history, and then I literally, Saturday, my friend, I sat with the Constitution to review it and review that section of Article 3, 4, to look at the surrounding sections as well. And I was looking to see, did I miss something? Where is it? So I feel strongly that the standard used by her in 2022 was incorrect, that our legislative history, the status quo of how we did things and interpret things, never applied to Congress. That for Congress, it was always the federal law and the 1965 Voting Act. And I actually honestly feel very strongly about that, and that is my purpose for being here.
Yeah, I understand that. So effectively, this executive order is very short, so he made it a point to put it in his executive order. So your position is he misunderstands why we're here.
I'm not saying he misunderstands, no. Don't put words in my mouth. I'm saying that I cannot speak for him, but I can speak for my reason, right? And that is my reason.
Does your reason align with what he believes that we're diluting black representation?
My reason is that we need to clarify the law because it's muddy. And that the standard used by Judge Battaglia was erroneous. And that if she had considered the 1969, 1970, 1972 constitutional amendment, those other cases, right? She would, and consider that there's nothing on Article 3, Section 4 related to Congress, that she would have applied the status quo, what we have used for 150 years.
That decision was, 4 years ago? And now we're coming back in a special session to address it? Why didn't we address it the last 4 years?
I can speak for us addressing it right now, okay? Which is important. And it's important because we also have to meet this moment, all right? These are unprecedented times. Delegate, I wish I was not here in front of you, but it's a nightmare. And again, my reason is to clarify that ruling, which was erroneous. I spent hours on Saturday looking through it to see where did I miss it? How did she get it so wrong? And I honestly feel that it was an incorrect ruling, that the legislative history and cases and our Constitution is quite clear.
I appreciate you, and I thank you for those words. I just don't understand how this is going to solve the nightmare that you're speaking of, other than to maybe go to the motive of what the governor has put out.
I can't speak to what the governor said. That was his, writing. He's not here in front of you. The legislative record in front of you is what we're saying right here, and this is my purpose and my why,
Yep, I
to
appreciate it.
clarify the standard.
Thank you.
Okay, we're going to go to the final question for this panel. Senator Carrozza, you have your one question.
Thank you, Mr. Chair, and I do appreciate the courtesy, and I want to thank the Senate President, Madam Speaker, and the Majority Leader for this dialogue. When I drove up in Beach traffic last night for hearing prep to be in my office overlooking the State House, it really occurred to me that this is a defining moment in Maryland history. And I do believe it is one of the most consequential in our public service. And why? Because we're changing the Maryland Constitution, which could have the effect of an 8-0 map, which eliminates a minority voice. And many of us have been clear that gerrymandering is wrong, whether it's in a red state, a blue state, it's just wrong. And we've experienced it here in Maryland. Those of us who are in the super minority and fight to make sure our constituents' voices are heard. That's why we're so passionate today. And now, I went through last night, there was little time for all of those who are opposing this across the state of Maryland because this hearing's being held, the special session's being held in summer. Even those who wanted to go on official record, it is a little challenging to kind of get in and log in, and we had our staff trying to help people who wanted to get their voice on the official record, but in the meantime, we've encouraged them to continue to communicate with us. And the reason I believe that they are so engaged with us right now is because the people understand that when you go from a 4-4 congressional map, then a 6-2 congressional map, and then a 7-1 congressional map, 7 Democrats to 1 Republican. That's the world we're in now. We have one Republican voice in our congressional delegation. And that the effect of this changing the Maryland Constitution, the effect could be this 8-0 map. It is going to eliminate the minority voice. And so what I'm asking you as leaders, and I respect you both, that just to please, do you understand the outrage and the strong opposition to those who would have their voice eliminated due to an 8-0 map?
Senator, I would say first and foremost, this is not a map. And I want to be very clear why I agree with you about the importance of this moment. Earlier this spring, after the Calais opinion, I sat down with a number of constituents, particularly women in my district at several different events, who talked about what they were witnessing in Tennessee as one of the most horrifying things that they'd have ever experienced in their lifetime, saying, I cannot believe that here we are in 2026, and what we're seeing happen in other states is eviscerating hard-fought efforts to protect individuals in individual states. And that pain was unbelievably real and unbelievably tangible. And why I say this moment matters is that something has to break. This cannot continue in the long term. This is the undermining of the long term of how our system functions. And the only way through it is to be in a position to have options to respond so that we get to a place where we are able to see the common interests again. I believe fundamentally that this clarification of our law is a step in that direction.
We represent Maryland. This is the 250th year of America's independence. Gerrymandering is wrong, whether it's in Tennessee, whether it's in Maryland. We have to focus on our constituents and make sure they have our voice, their voice is heard.
They will. That's why they will vote on this amendment.
That's right.
Okay, that's going to conclude this panel, and I'm going to thank you to the Senate President, Speaker, Majority Leader Moon. I'm going to turn to Melissa Wells, the Chair, to We're going to bring up our first panel of
Yes.
in-person witnesses, and I'm going to yield to you to do that.
Absolutely. Thank you again to Madam Speaker, Mr. President, Majority Leader for your sponsor panel. So we will begin with, just so folks know the order, everyone that testifies will have 2 minutes to provide their testimony, and we will be enforcing that. And we will begin with favorable testimony, will then be followed by favorable with amendments, unfavorable, all in person, and then we will turn to virtual testimony thereafter. So as folks can see or may not see, I believe we have 4 seats. We will call up 4 people for each panel. We will begin with the favorable testimony, beginning with Diana Bergman, James Montgomery, Willie Flowers, Jeannie Massey. All right, we'll begin on this end.
Good afternoon, chairs and members of the Joint Hearing Committee of the Maryland General Assembly. My name is Diana Bergman, and thank you for the opportunity to testify on House Bill 2100 and Senate Bill 2100. Throughout my life, I believe that good government begins by listening to the people. As someone who has dedicated my career to service, I do not believe in suppressing the voice of Marylanders. Our democracy is the strongest when we trust people to participate, engage, and help shape the future of our state. That is why I support placing this constitutional amendment before the voters. Regardless of where someone stands on the proposal itself, Marylanders deserve the opportunity to weigh in the facts, participate in the democracy process, and make their voices heard at the ballot box. If approved by the Maryland General Assembly, the amendment will go before Maryland's voters in November 2026 for their decision. Throughout my work in healthcare, education, and community advocacy, I have learned that the best solutions come from collaboration, transparency, and public participation, not from limiting opportunities for citizens to be heard. We may not all agree on every policy, but I hope that we could agree that Marylanders deserve the opportunity to participate in decisions that shape their government, respecting the voices of our voters, strengthening public trust, and reinforcing the democracy values that we all share. I respectfully ask for a favorable report on House Bill 2100 and its Senate counterparts, Senate Bill 2100, so that people of Maryland can decide this important constitutional question at the ballot box. Thank you for your time and consideration.
Good afternoon, Chair, Madam Chair, Mr. Chair, the esteemed committee members. My name is Jeannie Massey. I live in Washington County in District 2A, and I honestly hesitated to speak today. But yesterday, a friend of mine told me that one of her neighbors, a woman who had sought asylum through our courts, had been deported, leaving her 2 elementary-age kids with few to rely on. She's not the first mother in our community that's been removed. Another mom I know personally was taken from her children, her husband, and the thriving business that they built together. I live just 10 miles from a vacant warehouse in Williamsport that DHS plans to convert into a detention center for as many as 1,500 people. I believe we should call these warehouses what they really are, concentration camps. As a teacher, I spent many years in studying the Holocaust, and my education on the subject began much earlier. In high school French, we read Jacques Chirac's historic acknowledgement of the French government's complicity in the 1942 roundup of more than 13,000 Jews in Paris. Thousands were confined in the Vel d'Ive, a bicycle stadium. They didn't have warehouses. Before a deportation, many were ultimately murdered at Auschwitz. I learned early that history teaches us to recognize patterns: fear, scapegoating, dehumanizing language, the separation of families, the concentration of people behind walls, and government power exercised with impunity. These patterns are present in America today. The people being detained and deported are not abstractions. Many are people with no criminal record who have worked, raised children, worshiped, paid taxes, and built lives in our communities. They are our coworkers, our friends, our family, our neighbors. Whatever disagreements about immigration policy, their humanity and dignity should not be negotiable. There are serious practical dangers to Washington County as well. Although conversion of the warehouse has been paused, DHS has never adequately answered questions about wastewater capacity, emergency services, traffic, environmental impacts, public health, and long-term costs. As all of this brings me back to the legislation before you, healthy democracies depend on elected officials who must listen
Thank
to
you very much,
communities
Ms.
they
Massey.
serve.
If you could please wrap up your testimony quickly.
The district on the Eastern Shore is overwhelmingly one party, and that raises a question directly relevant to today's debate. What happens when elected officials no longer have to persuade a meaningful cross-section of the people they represent?
And I guess, Mr. Chairman and members of the committee, I represent the Howard County branch of the NAACP and am very proud to support the legislation as is. I thought I came here to talk about voter intimidation, literacy tests, and closing voting rights sites that created the history of the Voting Rights Act of 1964. But it turns out that it's about a process to create an opportunity for voters to weigh in on this bill and referendum. So the NAACP completely supports that and supports the decision to make this possible so that every voter in the state of Maryland could weigh in. So we stand in full support of House Bill 2100. Thank you.
Honorable chairs, members of both committees, my name is Jim Montgomery and I live in Montgomery County, and I am a long-term member of the Women's Democratic Club of that county. I thank you for this opportunity to speak in support of the 2100s and urge that your committee send it forward with a favorable report. I have been a practicing Democrat since 1948, when my father took me to hear Harry Truman at a whistle stop in New Jersey. I drew on those years when reading this legislation, and two phrases came to mind that I associate with my fellow Democrats. One, common sense. Two, democracy at work. For me, it is simple common sense that we Democrats do what we can, when we can, to oppose the Republicans' multi-pronged and deadly earnest effort to render our votes irrelevant. This is one of those moments. This legislation embodies common sense, and I urge you to support it. Secondly, this legislation is indeed democracy at work. It puts the question before all Marylanders in November. Its sponsors do not depend on backroom machinations or the outright cancellation of elections. No, they draw on their democratic roots. They put their trust in the people and put this question before all voting Marylanders, whatever their party. I urge you to support this legislation. Thank you.
Thank you. We have a question from Delegate Fisher.
Thank you. Thank you, Madam Chairwoman. A quick question. With House Bill 2100, while it's currently not in this constitutional amendment or this ballot question to put in front of folks for a constitutional amendment, there's an opportunity to put into this particular bill an independent commission that would then do all the redistricting in Maryland for the federal offices as well as for the state legislature. That's currently not in this bill. Would any of you support having an independent commission in Maryland's Constitution so that that commission would choose how state and federal legislative districts were drawn?
I think the commission is the Maryland General Assembly, and that has been the tradition in the past.
So that's a no then. Anyone else? That's fine. I know that's your answer. Can anyone else answer? Would they support that?
One more person can answer from the panel. We'll try to direct the questions to specific panelists.
Well, they're all for, they all support this, so I think it's fair to ask each of them. I'm asking this one question. It's pretty straightforward. A real simple question.
I think the House leader said it correctly. This is now, and this question is now. And the question isn't an assembly, it's a pair of bills that are the same, that are answering a very real threat to the validity of our votes. So I think that's the issue, not a commission.
Okay. And the two young ladies in the end.
Well, I am willing to work with everyone as long as we prioritize Maryland voters and their opportunity to actually participate in the process. So we're here today to testify in favor to give Marylanders that opportunity to actually have a say and be part of the process.
I appreciate the answer, but the question was really simple. Would you support an independent
She
commission?
answered the delegate, she answered the question. We have one more person to answer
Well,
the
it wasn't an
question.
answer, and it's
She
just
answered the question as she saw
say
fit.
yes or no.
I always plan too much as a teacher, so I didn't get to my point at the end where I think competitive elections are really important for the safety of democracy and the future of our republic. There has been some evidence that independent commissions can draw competitive districts. I don't know how to do it necessarily with Maryland's geography.
I appreciate your honest answer. Thank you.
Thank you. Delegate Tomlinson.
Thank you, Madam Chair. This question is for the woman closer to the center. Sorry, I didn't get your name. Did my ears, did I hear this correctly? Did you compare ICE detention facilities to concentration camps?
Yes. It was part of the plan from the Wannsee Conference that there would be a massive transit network using cattle cars and transit points, similar to the detention centers that have been described as Amazon warehouse centers that we need to treat the detainees like boxes and be more efficient.
I'm not Jewish, but I find that incredibly disrespectful to the 6 million people who did die in concentration camps to compare them to ICE detention facilities. That is just incredibly inappropriate, I think.
I apologize if that's your feelings on the topic. I have studied and worked with Jewish survivors and hidden children over the years. I feel very strongly that what we are doing right here in America is inhumane to our neighbors, to our friends, to the moms in my own community. I do think that there are similarities between what has happened and the way we are talking about our friends and the people in the other party. It's too easy today to just vilify someone on social media. We need to make a course correction.
I don't even know what to say to that, but thank you.
Okay, Senator Carosa, and if you want to direct it to somebody specific, in other words, we're going to get 4 answers on every question. Okay, Senator Carosa.
Thank you, Mr. Chair. This question is directed to Mr. Montgomery, and I might have misunderstood your testimony, but when you were talking about the diminished role of Democrats, were you talking about other states, or about Maryland? Because I was going to ask you if you knew the makeup of the Maryland General Assembly.
I was talking about what is occurring on the national level, and this is related to that.
Okay, so you're talking about in other states, not in Maryland.
I'm not talking about the state of Maryland.
Okay, thank you.
Okay, why don't we move, thank you for your testimony. Or is there anybody, oh, I'm sorry, Senator West. Get the last question.
Thank you, Mr. Chair. Just briefly, I want to make a comment. The last time I checked, this is to the lady who talked about the concentration camps. Last time I checked, people in these detention centers are not being murdered and liquidated. Thank you.
The situation in the camps themselves do have a great deal of similarity with the health conditions in a lot of the concentration camps, where for-profit corporations here are certainly making a great deal of money, and yet the food, the medical support, and honestly, collaboration with local medical and public safety, the situation is different in that we are sending them away rather than sending them to a death camp. Unfortunately, a lot of the people that we are sending away are going home to places that they don't know and places where they may be in danger, and that's why they came here in the first place.
Okay, Sarah West, let's not get too off topic here. Okay, let's stay on the bills before us. Any additional questions? Vice Chair Kagan.
Thank you, Mr. Chair. I just want to remind colleagues that we have allowed 50 Marylanders to testify today. We've given them a minute. We've given them a limit of 2 minutes to express their thoughts, their concerns, their support, or their opposition to SB 2100 and HB 2100. These are not necessarily constitutional scholars. These are not necessarily legislative analysts. They are our constituents, they are our friends, they are our neighbors, and I think we should listen and take in their thoughts and not try to give them the second degree or put them on the spot. Thank you, Mr. Chair.
Okay, so thank you for your testimony. Very much appreciated. We're going to next move to a panel of favorable with amendment witnesses. And if I call your name, come up to the front. I've got Max Sokol. Is Max, you here? Okay. Kate Stein, Spencer Rhoda, and Erica Puentes. These are favorable with amendments. We've got 4 seats, 4 witnesses. Okay, Mr. Sokol, since I started with you, you're going to be on the, each of you are going to be on the 2-minute, up to 2-minute clock. And again, you're signed up favorable with amendments. So, Mr. Sokol, you can start.
Thank you, Chair Feldman, Chair Wells, and the Joint Committee for the opportunity. My name is Max Sokol. I'm the campaigns director with Progressive Maryland. We are proud to have organized the Meet the Moment Coalition that is fighting for a transparent and fair redistricting process here in Maryland. We are all here because the Trump administration has colluded with Republican majority state governments to engage in unprecedented mid-cycle redistricting for the sole and explicit purpose of avoiding accountability from voters in upcoming elections. In the process, they have dismantled majority-minority districts across the country. Maryland has faced a huge cost in the form of job losses, healthcare cuts, and family abductions, to name just a few impacts that I know we are all feeling. Maryland must respond. So we at Progressive Maryland are enthusiastic supporters of these 2 bills, and we thank Governor Moore, Speaker Pena-Melnick, and President Ferguson for working together to bring them forward. With that being said, we continue to believe that voters should see a map, and we respectfully urge the Joint Committee to amend this legislation to include a map along with the constitutional amendment question. We believe this is the most transparent path to take. It's also in line with other democratic states in pursuit of voter transparency have done. Finally, it's the best way to respect the tremendous amount of citizen engagement that went into the Governor's Redistricting Advisory Commission. Since we all met to discuss redistricting earlier this year, 4 more Republican-led states have redistricted, eliminating 10 more Democratic districts, most of them black majority districts. Our Congress is currently being elected in Tallahassee and Austin. Maryland must respond to these direct attacks on our federal democracy. Our voices as Marylanders are being silenced by an administration that has heaped abuse on our state. For all of these reasons, we ask for your support for the ballot question and an amendment to include the Redistricting Advisory Commission map. Thank you.
Okay, why don't we go right there with the light on? Tell us your name.
Thank you, Senator Feldman. Good afternoon, Honorable Chairs Wells, Feldman, and members of the committee. My name is Erika Puentes, and I serve as the Legislative Coordinator for Progressive Maryland. I'm delivering this testimony on behalf of PMD. Progressive Maryland is a member-based grassroots power-building organization focused on advancing racial and economic justice with the goal of building a more just and equitable Maryland. We're grateful to both the House and the Senate for coming together to protect our democracy and the communities most impacted by the Trump administration's power grab. In Maryland, we have already seen the effects of the federal government's actions on the everyday lives of our residents, and we are bracing for even greater challenges brought on by policies like the so-called Big Beautiful Bill. 200,000 Marylanders are projected to lose health care coverage because of this reconciliation bill. And policies like these do not just impact one area of society, but they work together to push Trump's broader white supremacist, anti-working class agenda. For example, the support and money that the reconciliation bill takes from Marylanders, the cuts to health care, is being used to fund ISIS terror campaigns on our immigrant and black and brown communities. It's the money the reconciliation bill is taking from our pockets and from the state that is allowing ICE to shoot mothers in the head in Minneapolis. It's the money we are losing that is being used to brutalize and illegally detain racially profiled U.S. citizens here in Maryland, to drag mothers out of car windows here in Maryland, to leave kids without their parents, to rip Maryland families apart. All of this is unfolding against the backdrop of the rollback of civil rights that previous generations fought so hard to secure. This is why it's important for Maryland to fight back against Trump's attempt to control Congress. For these reasons and many others, Progressive Maryland urges the Joint Committee to pass HB 2100, SB 2100, and work diligently to ensure that Marylanders have the opportunity to vote on a fair congressional map this November. Thank you.
Okay, thank you. How about Ms. Stein?
Good afternoon, Chair and members of the committee. My name is Kate Stein. I'm speaking on behalf of the Montgomery County Women's Democratic Club, which is one of the largest and most active Democratic clubs in our county. WDC urges passage of HB 2100, SB 2100, and requests that the bill be amended to include the proposed congressional map developed through Governor Moore's public advisory process. Earlier this year, many Marylanders, including many members of WDC, participated in good faith in a transparent public process to help shape a new map. We educated ourselves, attended hearings, and respectfully submitted our testimony to the Redistricting Commission. We believed that our voices would count and that our legislators would represent us and so vote on the map. This did not happen during the regular session. We now have another opportunity to do so. We are glad that redistricting is being addressed in this special session. We believe this is critical. We ask you to do more to meet the moment. Even if passed in its current form by both this body and citizen referendum in November, HB 2100, SB 2100 will require a delay as Maryland engages in yet another process to once again draw a map. We believe this delay is unnecessary. Marylanders have already engaged in a transparent public process in good faith. With their input following the process, a map has been drawn. It is time to move forward. We urge you to pass the bill with amendment. The map that was approved by the Commission should be on the ballot. The constitutional amendment and the proposed map should both be put before the voters. As protections under the Voting Rights Act have been weakened and states across the country continue to redraw congressional districts, we are very proud that Maryland is stepping up to defend our democracy. We urge the committee to issue a favorable report with amendments to attach the proposed congressional map. Maryland voters should have the final say, and they should have the proposed congressional map and all the facts before they vote in November. Thank you for your time.
Okay, thank you. Mr. Rhoda?
Hello, I'm Spencer Rhoda. I'm a delegate candidate for 9A. The language of this referendum is intentionally misleading. It is being called a clarification, but the amendment introduces new language which is not properly summarized by this referendum. It should plainly state that it is stripping Marylanders of their rights to fair and contiguous maps. It should plainly state that the MGA intends to draw a map across the Bay Bridge because there's no possible way to have a contiguous map that disenfranchises Eastern Shore voters without doing so. When asked to allow bipartisan input to clarify this language, the Senate President flatly refused. Refusing to even entertain a discussion makes this whole proceeding a sham. The MGA is going to do whatever it wants, and it's important to understand why. Because the MGA wants to eliminate Maryland's only Republican congressman with blatant gerrymandering. Because they know that no court would uphold what they plan to do without this amendment expressly granting them the power to do so. Because this body of state legislators is more concerned with playing national games than concerns here in Maryland. As evidenced by the Senate Majority Leader being ousted in the Democratic primary by a socialist, this body is also obviously feeling heat from the socialist arm within itself and a possible takeover of the Democrat Party by the DSA. The Senate President was forced to agree to this or he would have lost his primary. It was both a savvy and slimy political play because it won him his primary narrowly, but it forced him to select his language very carefully here today. He says we face the single greatest threat to our democracy today, and that he needs whatever option we have as elected officials. The real threat to the liberty of Marylanders is an unchecked supermajority in the General Assembly. So we're here to talk about a voting referendum. I encourage all Marylanders to vote to keep their rights. And while they're at it, vote out the self-interested career politicians who seek to strip them of these God-given rights.
Okay, thank you to the panel. Questions? Why don't we'll go to, we'll go Senator Simon Ayer, and then we'll go to the House side. Senator Simon Ayer?
Thank you, Mr. Chair. This will not be 10 minutes. Thank you for testifying. I know it takes time to come down here out of your work and all that. I appreciate it. One thing I would say is no name calling. We don't need slimy things, but we get what you're saying. But to the question, the lady on the end, You mentioned Trump a lot and bullets to the head and ICE and support for fair maps. When the leaders presented this, they said this is just a simple clarification. So how do you think this bill will affect what you're promoting?
Absolutely. I mean, as the leader said, this is about clarifying standards for, for maps. It's up to voters to decide whether this constitutional amendment will go through or not. Our hope is that, as the vast majority of Marylanders have shown, they will support this, and our hope is that our leaders will put forth a fair map that we could also vote on.
And when you say fair, would that be based on population, or were you hoping for maybe to get, right now it's 7-1 Democrat. I guess the question is, do you think that's fair currently?
What I think is unfair is the intentional dismantling of Black majority districts all across the nation. What I think is unfair is that a lot of populations, Black communities, LGBT communities, brown communities, immigrant communities, et cetera, are losing a voice in Washington. And what I think is fair is that Maryland stand up against this and ensure that our communities have that voice in Washington. That would be fair to me.
Okay, and last, just clarification. I get what you're saying. I completely understand where you're coming from. And we have a 7-1 map. How do you think this bill is going to help fight the things that you're saying? Do you think it'll become an 8-0 map? Is that what, I'm trying to understand why you think this bill will help you. If you put more Republicans in, I don't think you think that would help you. I'm just trying you to voice how you think this bill will address the issues that you're talking about, the unfairness at the national level.
Yes, again, if voters vote for this constitutional amendment, our hope as an organization is that we will also get the chance to vote for a map that would protect the voices of the most vulnerable in our state and across the nation.
Okay. Chair Wells?
Thank you. And just to, again, please direct your question to a specific panelist. We'll begin with Delegate Fisher. We're moving on to Delegate Fisher. Sir, we're moving on to a question from Delegate Fisher. Thank you.
Thank you, Madam Chairwoman. This is for Mrs. Stein. Thank you for being here. My question is, you're head of one of the Democratic groups in Montgomery County, if I'm correct.
Who's the head of the Women's Democratic Club?
Okay.
I lead advocacy for the club.
But
I'm speaking
Montgomery.
on her behalf.
Thank you. Would you support amending this bill that's before us today to require an independent commission to heretofore draw all congressional and state legislative maps in the state of Maryland?
I think we need an independent commission to do that. I think that right now we need to move forward with what we have in front of us, what you have in front of us. I do support that. I support a whole bunch of other changes to our democratic election laws, including that. But right now we need to move forward with this.
So you do not support amending this bill to have an independent commission? Okay.
I do not support amending this bill to do that, but I do think that that should be done, and it should be done in the next session.
And in Montgomery County, there are 100,000 Republicans who are disenfranchised because of the extreme gerrymandering by the Democrat Party, who controls the actual redistricting process. Do you find that troubling, being from Montgomery County, that alternative voices are not allowed to ever get elected because of election rigging?
I don't agree with the characterization that there's gerrymandering. I would say that, again, I support a whole bunch of other democratic measures. I would support open elections, open primaries. I support publicly funded elections. I support all sorts of things to make sure that people's voices are actually heard.
Got it. But just not an independent commission today, of course not, because that would just be too fair. Thank you.
Not today. I do think that that should be done.
All right, thank you. Delegate Sample Hughes.
Thank you, Madam Chair, and thank you to the panelists that are here today. This question is for the first panelist, and I didn't get your name, sir, and I believe Kate as well. Both of you have referenced the regards the amendment that you would like to have the 8.0 map attached. My question for you, and this is what I'm certainly hearing from my constituency, from a rural community, in your research and in your reference to that map today, are you at all concerned or have thought about the fact that the rural community, the voice, as well as funding from the federal level could potentially be diluted by the current map that was proposed? And I know, as our leadership said, we're not here talking about a map, but in all reality, that's where it's going to go, okay? So that reference that you made, and specifically that particular map, has that come to your mind at all that would potentially dilute funding opportunities for the rural community, or even having rural representation?
I think that what we are saying is that we all went through a lengthy process of the Governor's Redistricting Advisory Commission. A great deal of citizen testimony was heard. Many of these issues were dealt with at that time, and that map was a result of that process. There are many issues with any map that can be created, as we all know. What we are saying is that given all of the work that went into that transparent process, why would we not move forward with the result of that process?
I can't really add anything to that. I agree wholeheartedly. It's about making sure that all of our members, all of our citizens who gave their time and their energy, again, educated themselves, showed up, went through the rigmarole to have their voices heard, and did it in good faith, publicly, transparently, that the outcome of those efforts is put before the voters.
Well, lastly, I'll say, certainly I applaud anyone's effort to take time to do research in public service. But a resident of the Eastern Shore, it certainly is concerning about me, about future funding, about future representation. And so I didn't hear either one of you particularly make your response to that question that I asked you. Was pretty much about, the efforts and research and everything that went into that. But that's what I'm hearing from the citizens.
Well, I'm not from the Eastern Shore and wouldn't
Right.
presume to speak for anybody on the shore. I can say that many of the folks in our coalition are from the Eastern Shore and are parts of organizations on the shore, and they were supportive of that map. So I fully respect that, any map we come up with, there are going to be folks who feel this is not the right map for our state. That's part of the political challenge that we're all going through. But I can assure you that we do have members on the shore who support that map.
Okay, thank you. Thank you, Madam Chair.
Thank you. Delegate Chisholm.
Thank you, Madam Chair. Just in an effort for transparency and allow you to respond, I know you wanted to respond. Would you like to respond? I know you were trying to speak and didn't have the opportunity.
Self-preservationist play that has caused us to be here today. Would we be convened today if Bill Ferguson was not facing a serious primary
Mr.
contender?
Rhoda, we're not going to speak to the personal motives. You have one more time if you want to address it, but you do not
It's a
need to personally
self-preservationist
motivate it.
play, and he's coming
Mr.
out here and he's
Rhoda,
saying, we'll do
you're
whatever
finished.
it takes.
Mr.
We'll do
Rhoda,
whatever
you're
it takes
finished.
to
You're
stop
done.
irony in the White
Turn
House.
off his mic.
And
Mr. Rhoda, you're excused. You are excused, Mr. Rhoda. For the public, I think my good colleague in the Senate said it earlier, but we are not here to impugn the motives of anyone in this room, of anyone who has spoken previously as a sponsor, okay? We will have a civilized conversation. I respect that there are differing opinions. I have a list here that reflects that. But we will not impugn the personal motives of anyone in this body or outside this body. That is what we will abide by this afternoon. So with that, we have no more questions for this panel. We will move on to additional favorable with amendments. Thank you very much. We have, next on the list, we have Eliza Smith, Daryl Jones, Isola Shaw, and that's the last of the favorable with amendments this afternoon. Thank you very much. And just to be clear, sitting at the desk we have, is that Ms. Isella Shaw? I don't see Daryl Jones. Is Liza Smith with us? No, okay, all right. All right, we'll begin with you on my right. Thank you.
Okay, I'm going to be mindful of the time. I promise I won't go off and right. My name is Lisa. First of all, thank you, chairpersons and member of the committee. My name is Lisa Smith, and I'm testifying today on my personal capacity. I also serve as the elective District 14 representative on Montgomery County Democrat Central Committee. And today I express my view as owning my views. I appreciate this opportunity to testify on House Bill 2100. Earlier this year, during the regular session, the Maryland Senate passed legislation establishing special elections to fill vacancy in the General Assembly by an overwhelming bipartisan vote of 43-1. I respectfully ask this committee to build on that and support considering an amendment to the House Bill 2100 that would ensure Maryland voters' net appointments determine who represent them when legislative vacancy occurs. Now I'm going to go off script because for the last few minutes, it really got under my skin when people kept mentioning race. I've been born and raised in the South. Yesterday would be my mother's 10th year of passing. And when she died, she had her card where she had to pay voting poll tax. And so a third of the people who represent us, who has an impact on our lives, were not voted for. They were appointed. So when you come here and say that you're for democracy and you're for voting and for black people voting, but yet you don't want to put that on an amendment here, I sense your only focus is just to disenfranchise 25% of the Maryland voters. I ask today to include special election on this bill. Thank you.
Good afternoon, Chair Feldman and Chair Wells and members of the committee. My name is Isola Shaw. I'm a Rockville City Council member and a former federal employee. After 20 years of service, I lost my job at the NIH when the Trump administration abruptly fired our entire department, 150 of us. That moment was not just about a job. It showed me how unchecked decisions in Washington can devastate working families right here in Maryland. As a city council member, I've seen how these cuts ripple through our communities on the local level. They do not just stall research or public health services. They pull the rug out from under families, threatening jobs, healthcare, food security, and daily financial stability. In Trump's first year of this term, Maryland lost 25,000 federal jobs, more than any other state. That is why redistricting matters so much. It is not just a political exercise, it is a tool to check power and protect Maryland's workforce and our communities from the fallout of decisions made in Washington. Across the country, we are seeing voting rights and fair representation come under attack, especially for working people and communities of color. Maryland cannot afford to stand still. We have a responsibility to make sure every family has a voice and that our state continue to stand for fair representation. I urge you to pass the constitutional amendment and adopt the proposed congressional map during this special session. Maryland voters are best served when they see both side by side before making a decision that will shape their future. Thank you.
Thank you. And just want to call one more time Daryl Jones if you're here with us. Okay, seeing none, we'll move to questions.
Go ahead, Senator Simoner.
Yeah, thank you. And just a quick question. I'm sorry about your job loss. I know that can be very traumatic, and thank you for testifying. The same question I have for you. How is this bill going to help that situation? How do you see that?
I see that this bill will provide more overall Maryland representation nationally. and this can help to protect our workforce in general. And I also think that making sure that this goes directly to the voters to make their decision as well, this will also just help our overall process.
Okay, and thank you. Just a quick follow-up on that. The struggle I have is I hear stories like you that touch my heart. But I also think of the millions of people in Maryland who are going to have their voices suppressed to get that 8-0. And I understand the national politics, and I think the speaker said we can't disarm now and so forth. But we're in a sense, we are keeping millions of people hostage until they resolve this national crisis. And it's hard for me to justify that one extra seat by doing that. Does that go into your thinking at all? Primary, only 20% of the people get the vote if the maps are arranged in a certain way to get 8-0. And then the other 80%, it's already decided.
As a city council member that is in a nonpartisan election, I do think it's important for this bill to go directly to for this ballot measure to go directly to the people to let them decide.
Thank you.
Okay. Thank you for your testimony to both of you. Okay, we're going to pivot to a panel of unfavorable. So if I hear your name, come on up. Elliot Herniker, Nathan Davies, Jonathan Alexandra, and Leland Bradshaw. Those are 4 names, 4 seats. Okay. Well, let's, how about we just go down the table, sir, with the light on right there. We're going to start with you to my left, and then we'll just go down the table. Each of you are on the up to 2-minute clock.
Good afternoon. My name is Nathan Davies. I'm a resident of the 1st District, and today I express opposition to these bills on behalf of every student in the Maryland Federation of College Republicans. Amongst Maryland Democrats, there is this idea floating around that judicial oversight in congressional mapmaking represents a heinous departure from tradition. They claim that in 2022, the court overstepped its bounds and must now have no say in preventing extreme gerrymandering. This is, however, a misguided conclusion. Court oversight did exist long before 2022. The limits of the basic constitutional guardrails had simply never been tested by such an ambitious attempt to toss out the representation of every Republican in Maryland, a state that chose a Republican governor just 1 term ago. Characterizing these bills as clarification rather than perversion of the pre-2022 standard is nonsensical. This reminds me of an insightful analogy, Chesterton's fence. Picture yourself wandering outdoors in unfamiliar territory. You happen across a fence whose purpose you don't immediately understand. You shouldn't hastily tear down the fence, though it may be tempting. Instead, you must determine why the fence was put there in the first place. What purpose does it serve? In this example, the fence represents constitutional standards enforceable by judicial oversight. Rather than rushing to tear down the fence, in this case, erasing protection from partisan gerrymandering, we must all recognize why the protections exist in the first place, to sensibly guard the voices of minority party Marylanders. For instance, recognizing our beautiful bay as a hard natural barrier to the slicing and dicing of districts at the whim of the ruling party. In 2022, the fence did its job. In 2026, the legislature and all Marylanders must recognize why the fence is there and why fair governance depends on its presence. Thank you for your time.
Okay, thank you. Next up, sir.
Chair, Vice Chair, members of the Government, Labor, and Elections Committee, thank you very much for this opportunity to testify before you all. My name is Elliot Herniker. I'm a lifelong Harford County resident and a candidate for the House of Delegates in District 34A. I sit here today in opposition to House Bill 2100, not because of which political party it may benefit, but because of the principle at stake. Voters should choose their representatives. Representatives should never choose their voters. My concern is that this bill changes the constitutional framework governing congressional redistricting in Maryland. I believe Maryland should be strengthening public confidence in our elections, not creating greater uncertainty about whether political interests are being placed ahead of the communities people call home. When voters no longer believe the process is fair, it plants the seeds of doubt, erodes public trust, and can leave people feeling disenfranchised and disconnected from their own government. This debate is also happening while Maryland families are struggling with rising utility bills, housing costs, grocery prices, and the increasing cost of everyday life. Those are the conversations I'm having every day with the people I hope to represent. My position would be exactly the same regardless of which political party stood to benefit. Fairness cannot depend on who is holding the pen. If I have the privilege of serving in this building one day, I never want to win because the rules favored me. I want to earn the trust of my neighbors one vote at a time. For those reasons, I respectfully request an unfavorable report on House Bill 2100. Thank you.
Okay, thank you.
I'm Jonathan Alexander. I'm an attorney and legislative counsel for the Maryland Family Institute. In opposition to this proposal, the candor that's been expressed all morning is quite extraordinary. The bill text saying that it declares that nothing in this article or anywhere else in the Constitution, including our Declaration of Rights, can act as a criteria. You know, this is the same Constitution that promises its citizens the right to participate in the legislature, to enjoy due process and equal protection, and to have free and frequent elections. And so for the proponents to then declare that these guarantees simply do not apply when we choose our boundaries for Maryland's congressional seats is really brazen attack. It's incompatible with the guarantees of democracy. You know, what of the words compactness? What of the words equal protection and due regard? All these standards in Article 3. Well, this bill comes in and says, no, 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 Maryland, you have no authority here. So I asked, by what authority are we going to judge our maps? You know, the standard certainly can't be by disenfranchising nearly half of Maryland voters. The standard certainly can't be by the intentional elimination of a type of voice for partisan politics. The standard certainly should not be and cannot be by isolating groups based on some artificial or preferred classification. Anytime that has been done in the past, it's been struck down at the highest levels. But we're playing this game again, and this time we're doing it to silence yet another generation. We're doing it to silence a young group of voters who are increasingly coming around common sense principles, who are rejecting extremism, who are coalescing around what makes Maryland a special place to live. But this amendment is saying nope, no to all that. There's only one political party that speaks on your behalf. For those reasons, we encourage a no vote to ensure that we maintain fair and equal voting rights for future generations.
Okay, thank you.
Chairs, vice chairs, members of the committee, my name is Lee Bradshaw, and I'm the legislative director of the Maryland Forward Party. We oppose these bills and this amendment because partisan gerrymandering, regardless of the party who benefits, regardless of the current circumstances, is undemocratic. What would be fair is an amendment that gives Maryland voters a nonpartisan, independent redistricting commission by the 2030 census. We have an election in November. We have 4 years to accomplish this. This would provide legal criteria in the Constitution for districts. It would provide fair districts. It would provide clarity for Maryland voters. Thank you.
Okay, thank you to the panel. Questions for any specific witness? Senator Carrozza.
Thank you, Mr. Chair. Thank you all for your testimony, Mr. Alexander. Wanted to follow up on your testimony. We also received information from Mr. Paul McCosby from the Maryland Family Institute. And in his testimony that he sent in, he talked about that the organization is very concerned about the legislation the potential to undermine the freedom of the people of Maryland, which is, pretty general. Can you elaborate a little bit on that?
Yeah, I think it's a fair assessment, and obviously I agree with what Attorney McCosby says in that statement. I think he's alluding to the fact, something that it's plain on its face, that if the guarantees of this amendment, or if this amendment were to go in the opposite direction, where you'd be gaining more conservative Republican seats, you wouldn't have sort of this show or this presentation or this urgency to rush it through. What this is attempting to guarantee is that there is only one political voice at the congressional level representing Marylanders, and that is getting rid of nearly half of Maryland voters. It's getting rid of those that stand on common sense principles, those that stand on family values, those that are rejecting extremism from either party or extremism that they're seeing play out across the country. Maryland has always had a choice to consider DC politics but distance themselves from it. What this is doing is playing our hand right into what federal politics wants us to do, but it's doing so for a political party that excludes any other vote. That 8-0 count will exclude any other independent or conservative Republican vote in this state, and that's not what a fair and frequent and free election should be.
One brief follow-up, Mr. Chair.
Okay.
Thank you for that. I just wanted to follow up, when you talk about one-party representation, whether it's Republican or Democrats, and we hear that that's not good for the people overall, all citizens. Can you elaborate on that?
Yeah, as stated, if this were to yield the results of the proponents opposing party winning, they wouldn't have such a show. They wouldn't have called a special session. This is a clear attempt to have one party continue to be the only congressional voice and the only congressional representation. And that is going to be at the detriment of not just the district that the lone conservative Republican voice represents, but at the detriment of many in this country that rely on good appropriations, good budgeting, good fiscal responsibility that comes in part with a strong fiscal conservative voice. The fact that our budget is out of control at the state, at the federal level, can be mitigated by strong conservative policies that do come from a fiscally conservative voice. That's the very voice that they're attempting to eliminate.
Thank you.
Sorry, thank you. Delegate Fisher.
Yep. Thank you, Madam Chairwoman. Jonathan, also for you, should districts, whether they be congressional districts in Maryland or state legislative districts, be drawn based on the way people look?
No.
And why is that?
We're all created in God's image, and we are endowed by our Creator with rights that surpass any characteristic, artificial or natural, that are placed on us. We've worked through this country to overcome the badges of slavery and to attempt through civil rights law and through the Voting Rights Act mitigate the true harms that did occur in our country. And the scars and wounds are there. But you cannot continue to pick at scars and wounds and project for the next future years of this country the same standard that we have worked our way through. What all that will do is bring us back to a time where the only classification that matters is what you can see on a person's visual appearance. And we've fought hard to get rid of that in terms of the standards that we have for folks being meritorious or folks being credentialed in society. We're past the point where race should be a factor for someone having credibility and should not be a factor either for our congressional districts.
Thank you. Because there actually are black Republicans, aren't there?
Absolutely.
Thank you, sir.
Delegate Tomlinson.
Thank you, Madam Chair. This question's also for Mr. Alexander. You were kind of touching on this when you gave your remarks a little bit ago about how when this bill, when this bill passes and the constitutional amendment goes on the ballot and probably passes, it's going to allow the majority party, when they redistrict, which they will, to have essentially no rules when it comes to the criteria for redistricting. In your opinion, is there any reason why aren't we using this opportunity to say that, hey, we've gone back and forth on this 2022 Circuit Court decision. You know, we can agree or not agree that it was the right decision, but why aren't we taking this opportunity, in your opinion, to say, hey, with congressional redistricting, we should take into account, the criteria should include adjoining territories, be compact and formed, just like with the legislative districts. Why aren't we doing that?
Yeah, the fact that there's no standard is very glaring, and without casting any dispersions on the intent, it does seem like self-dealing, that this is preserving the seats and the opportunity for one party to have control of the congressional seats of this state, and that's wrong.
Thank you.
Okay, I think seeing no further questions, I'm going to go back to Chair Wells for another panel of unfavorables. Thank you all for your testimony.
Thank you very much to this panel for your testimony. Calling next Blanca Tafawasco, Adam Straight, Fitzgerald Mofar, Michelle Kreisman. Let's see, are all four here? I think so. And I'll begin with, in the order in which I called you. So we'll begin with Ms. Tapawasco. We'll begin with Blanca for testimony. You have 2 minutes.
Thank you. I would like to thank the committee for this opportunity to speak today, Chair Wells and Vice Chair Carr, and the distinguished members of the committee. Our incumbent Democrat governor stated this special legislative session directly addresses the threats to the foundation of our democracy. Please allow me to point out that former Maryland Democrat Governor Martin O'Malley stated he set out to draw a map favorable to the Democrat Party and said, in quotes, "That was certainly my hope, and it was part of my intent," end of quotes, adding he also intended to create a district where the people would more likely vote for a Democrat than a Republican. Yes, this was clearly my intent, end of quotes. This quote was published on the Daily Record on June 2nd. 2017. Republicans and concerned citizens attempted to challenge the Maryland gerrymandered redistricting maps in 2000 and in 2010. Former Governor Larry Hogan fought hard to establish balanced congressional districts in Maryland, but this body, the Maryland Democrat Legislature, vetoed that bill. Today, Maryland, we are here again, once again worried about the latest gerrymandering scheme being perpetrated by this Democratic body. This committee established restrictive rules of who could testify in person and how testimony could be submitted in writing, truncating the opportunity for Marylanders who oppose House Bill 2100. The Maryland body, us who are voting, needs to realize altering the Maryland state constitution is not a responsible action. This legislative maneuver has nothing to do with saving democracy. This is the heavy-handed tactic on an untrustworthy majority party that wants to further consolidate its control and power.
Thank you. Mr. Straight.
Chairs and members of the Joint Committee, my name is Adam Straight, and as the Cecil County Executive, I strongly oppose the purpose of this special session, which seeks to amend Maryland's Constitution to legally gerrymander congressional districts to secure a seat that could not otherwise be won on the merits. The most important question is simple. Why are we here? Marylanders are facing an affordability crisis, much of it driven by state policy. Families are struggling with higher taxes, increased registration fees, rising energy costs, and regulations that have made the American dream of homeownership a nightmare. They are being asked to pay more while getting stuck with unfunded mandates, financial burdens, and budget deficits. Marylanders are so nickel and dime that they no longer pay with their wallets, but through the nose. Yet, this special session addresses none of these things. Instead, as we celebrate the 250th anniversary of America, this body is convened to undermine the very foundation of our constitutional republic. That voters get to pick their leaders, not the other way around. Many Marylanders will view this as placing political advantage over public interest. And it's not lost on me that not one District 1 resident spoke in favor of this, but there's been plenty of District 1 residents who are speaking against it. Governing is about priorities. They elect us to solve real problems, not political ones. I respectfully urge an unfavorable report on House Bill 2100 and Senate Bill 2100. Thank you.
Thank you. Mr. Mofar?
Last year, the Democrat-led Legislative Assembly passed the largest tax bill ever in Maryland history at $1.6 billion. Right now, Maryland has the highest utility costs in the United States of America. When going door to door in my district, I've talked to mothers and fathers who've told me they have no way of paying their BG&E bill. When going door to door, there's not a single person that talks to me about the need for mid-decade redistricting. Juvenile recidivism is out of control in the state of Maryland right now. And there was a 13-year-old that got shot by another 13-year-old. Also, residents in Howard County are still afraid to go to Columbia Mall after the shooting that happened with Emmett Zaya a few years ago. Mid-decade redistricting and anything that's happening in other states or the Louisiana versus Kalea decision is not applicable here. This is the status quo and business as usual here in Annapolis, where politicians disenfranchise voters to further consolidate power at all of our expense. Now more than ever, we need legislative leaders that are going to focus truly on affordability issues. We need to lower taxes to make sure that people keep more of their own money. We need to actually provide and bring more power plants online to lower utility costs. We need to upgrade our school infrastructure. We need to provide accountability for repeat juvenile offenders. Guys, I urge this body to please vote against this measure. And if you guys are so intent on voting this measure, also add independent redistricting committees in this bill. Add special elections in the case of a vacancy, which we do not have. Also add open primaries to stop the disenfranchisement of independent voters in our state, which is a growing population more than the Democrat or Republican Party. Please vote against this measure. Thank you so much, and I'm open to any questions. God bless you.
Ms. Chrisman?
Hi, thank you very much, Michelle Crispin. Dear Senator Feldman, Senator Kagan, and members of the committee, thank you for the opportunity to testify today. I am Michelle Crispin, sharing my own thoughts. Separately, I am also the longtime legislative chair for the Harford County Republican Women. I urge this committee to reject House and Senate Bill 2100 to ensure fairness, competitiveness, and respect for Maryland voters. It is clear to many that you have chosen to convene not to confront Maryland's challenges, but to redraw the lines of power. At a time when our state faces a credit downgrade, a weakening economy, rising costs, struggling schools, and families leaving in search of better opportunity, this body is not meeting to solve those serious problems. You are meeting to redraw congressional maps. In other words, and I say this very respectfully, steal the vote and take away our only conservative voice in Congress. Let's be honest about what this is. This is not reform. This is not necessity. This is a deliberate effort to entrench power. You call it redistricting. Marylanders see it for what it is, a political calculation that puts incumbency over integrity and advantage over accountability. And the cost is not abstract. Every line drawn for political gain erodes public trust. Every district engineered for certainty diminishes the voice of the voter. Every decision made in pursuit of control rather than representation weakens the very democracy you are sworn to uphold. For 24 years, I built a doctor's office. I learned something simple but important we all keep hearing today. Break the fever. A fever is not a disease. It is the body's response to fight. You don't cure the illness by silencing the symptom. You address the underlying problem. Our Maryland Constitution works the same way. It is designed with checks and balances to protect against overreach, to preserve fairness, and to ensure that the power remains with the people. Thank you for your time, Michelle Chrisman, very respectfully.
Thank you very much to the panel. We have a question from Delegate Tomlinson.
Thank you, Madam Chair. Questions for the County Executive of Cecil County. You were talking about affordability, and I just wanted to ask you about your county specifically. I'm from Carroll County. I live personally 2 minutes from the Pennsylvania border. I mean, I've seen my sister move there. My brother's coming back from Florida. He can't find anything around here, so he's going to Pennsylvania as well. And I'm sure in your county of Cecil, where you border Delaware, Pennsylvania, you've got to see it happening all the time. So are you seeing folks move out of Cecil County because they can't afford it?
Yeah, yes, actually, thank you for pointing that out. My county does border Pennsylvania and Delaware. We have no sales tax in Delaware, so our small businesses are suffering because people go over there to shop. We have Pennsylvania, who has lower property taxes. So we have folks that are leaving to go across the line, but they're right across the line so they can still be near their families and friends, but we're losing them. We're losing good folks in Cecil County. We're losing that taxable income, and who suffers from it? We do. The state suffers from it. Everybody suffers from it. Maryland has had the second worst economy in the United States. This is nothing to be proud of, and this is something that we should be fixing here today with a special session, not play political games. Respectfully, the frustration on our end is very, very real.
Thank you.
Delegate Fisher.
Thank you, Madam Chairwoman. To Mr. Mofor, in Howard County, are there any Republicans elected to the state legislature that are left?
No, there's not a single Republican that's been elected to the state legislature in Howard County. As a matter of fact, the last Republican was Trent Kittleman. And in that 2021 redistricting cycle, I believe they actually removed Carroll County out of the district to put Montgomery County into the district to give the Democrat Party a competitive advantage to actually flip that district. So extreme partisan gerrymandering also harms us at Howard County on a local level too as well.
So Trent Kittleman, she served in the legislature. I knew her well. When the Democrat Party, which is the majority party in Maryland, and also the party that draws state legislative and congressional districts, redrew, the long-time rigged game that we're all part of here in the state. I mean, Howard County has an enormous Republican voter base, in particular in the western part of the county, right?
Yes.
I know this because I lived there at one point, many years ago. But it's remarkable that through many years of gerrymandering and rigging that there isn't. So would you agree that today would be an opportunity, if anything, among the affordability issues to have an independent commission, constitutional amendment where once and for all elections are, the rigging by the Democrat Party in Maryland ends once and for all, where you don't have the umpire on the side of one team, and finally have a principled approach to drawing districts?
Yes, and you're 100% correct, Delegate Fisher. That western Howard County side, the Glenelg, Lisbon, West Friendship, that is a conservative area, particularly in Howard County. And I will 100% support independent redistricting committees. It's actually a necessity here in Maryland.
Thank you, sir.
Okay, Senator Carrozza.
Thank you, Mr. Chair. This question is for the county executive. Straight, please. I received testimony from Mr. George Tunis, who is the chair and CEO of Hardwire in my district, and that's a manufacturing facility that makes body and vehicle armor for the military, law enforcement, and depends on both defense contracts and other work. He wrote in his letter, he said, "I've worked in the small and diverse community of Pocomoke City, helping transform a once sleepy town into a globally competitive manufacturing center." And then he went on to say that, and I don't want to get into individual personalities, but the current representative had been helpful in securing millions of dollars in federal investment for Maryland's defense industrial base, meaning that when you have a representative that's of the same party in Washington now, that can be helpful, similar to the point that my colleague from the Eastern Shore made, that can be helpful to areas, rural areas on the shore and other parts of the state. So my question to you, because I think you alluded to, some of the economic challenges that you're facing, are you hearing from some of your business operators that, that the impact that you could, the negative impact that you could possibly have with the effect of an 8-0 map and how that could impact the county that you represent?
Well, sure. I think any kind of change mid-game like this has people wary. I certainly want to thank the letter writer for taking a chance on Maryland and being a manufacturer. As a retired police officer, I certainly appreciate him making things for law enforcement to keep us all safe. I think, to me, and to my constituents, the bigger question is that for those of us on the Eastern Shore in the 1st District, we look at the candidates that want to run, right? There were a couple of people in the primary on the Republican side. There were a couple of people in the primary on the Democrat side. And you vote, and these are the people that you want to represent your party, and we go from there. We're pretty good about picking the folks that represent our values, that represent our needs. Just because something works in, say, Montgomery County doesn't necessarily mean that it works in Cecil County or other areas on the Eastern Shore. This is why we have different representation. And let's just call this what it is. I know that it hasn't been said here, but from past comments from the governor, from other folks, this is targeting the legislative district, the congressional district, of the 1st District. It is.
Well,
and
my
we don't like that.
My question to you was more specific on, you have a successful business operator who is saying on the record that stable representation and bipartisan cooperation, because recognizing that the congressional delegation is a 7-1, that the one right now is reflective of the party empowered at the federal level. And my question to you is, are there other business operators in your county that take that same approach and would benefit from, a 7-1 or more map than an 8-0 map?
So I think those folks are more concerned with having elected representatives that listen to them. Certainly in Cecil County, I will work with anybody, no matter their political party. I've proven that. But the folks in my county, in Cecil County, want representation from folks that are like-minded and hold their values. And I think our current representative does do that.
Thank you.
Okay, thank you. We have 2 last questions. Delegate Solomon, followed by Delegate Stewart.
Thank you, Madam Chair, and I guess I will be brief. And I don't know that it's necessarily a question directed to one panelist in specific, but I know since we've had this conversation about disenfranchising
Delegate,
voters.
Out of fairness, please direct us to
Yes,
one person. I appreciate you. Thank you.
I guess very quickly to the gentleman from Howard County. Based on the conversation that was had around sort of impugning the legislature and drawing Howard County districts, by the argument that you were making earlier, a county race would have indicated that there was strong Republican representation. I guess just very quickly, was there or was there not a Republican nominee for county executive in Howard County in this election?
No, there wasn't a Republican.
Thank you.
Yeah, but however, there was a Republican candidate that decided to run as a Democrat because of the issues that we're at here today. Unfortunately, it seems like there's only one political party that could represent the people of Maryland, and more people are tired
Mr.
and
Mofar,
frustrated with
you
this
answered the
and
question.
deciding that they're
Thank
only going to
you.
run as Democrats
We'll move
to
on
get a
next
fair
to
share.
Delegate Stewart. Thank you very much.
Thank you, Madam Chair. And a little bit like Delegate Solomon, this could probably be addressed to any four of you. I guess I'll direct it to Ms. Crispin just because I think she's been left out a little bit and hasn't had a chance to answer any questions. But all four of you really sounded, I think, a very similar theme, which is, why are we here? You know, shouldn't we be addressing affordability issues? Shouldn't we be addressing economic competitiveness? Why are we instead focused on this bill? And so I guess to you, Ms. Crispin, would you agree with me that federal law has an impact on household budgets and affordability in Maryland? That federal policy can actually has a big impact on, for example, what we're paying at the pump right now?
Yeah, thank you, Delegate. I appreciate your time and question. I think it's a trickle-down effect. I mean, we all see that, federal in connection to local, state. We all work as one unit. And the reality is we all have freedom, right? Maryland constitutional freedom. We could even override that and say we have the big picture constitutional Bill of Rights. And at the end of the day, when somebody steps up to the plate and runs for a political seat and also goes to place their vote that people have fought for and died for, we want to have a choice. And to step back and say that, we may possibly not have a voice because of the supermajority, that's unacceptable in America, and especially also in Maryland. We must have a voice. That is our freedom, and you cannot take that away. And I appreciate your time.
Yeah, and I appreciate that message very much. My question's a little bit more narrow, though, because it sounds like we agree that federal policy can actually affect affordability in Maryland. And so if that's the case, I'm wondering why your testimony framed us being here today, which has to do with congressional representation, in other words, who has seats in the U.S. Congress. I'm not sure why that's being framed as a distraction from affordability if we can all agree that federal policy in part impacts affordability. You see what I'm saying? Can you help me with that?
I fully, absolutely understand. I'm a very intelligent woman, and my answer is still the same. And to add to that, freedom is very important to stand strongly for, and that's what I'm here today. My freedom to vote. My freedom to decide who will represent me, whether it is in Congress, whether it is the President of the United States, whether it is my senator, who I love over there in the corner, Jason. He's wonderful. He does a great job for Harford County, Maryland, and whether it is my House of Delegate member. That is my freedom of choice. And I say with a lot of respect, whether you want a blanket statement as federal, state, local, at the end of the day, I am here because it's important to stand for freedom and the freedom to vote, whether you're Republican, Democratic, or Independent. That is my choice. That is my answer, and I very respectfully thank you for your time.
Okay, I'm sorry that we couldn't get further with that, but I will agree with you on one point, which is that I also like Jason.
Yeah, have a great day. Thank you.
Okay, we're going to go actually one final question for this panel from Senator Simon Ayer, and under our agreement, he has one tiny, small question.
Thank you. If you'll all answer in 5, no, I'm just kidding. I'll direct this to the county executive. It was interesting, my delegate colleague brought up the situation about countywide elections opposed to a segment, and he said, what do you see? At the state level, in the last 24 years, we have had 3 Democrats and 3 Republicans elected as governor, which show it's pretty well even. But now we have 7-1 Congress seats, and they're trying to go to 8-0. Does that seem fair?
No, it doesn't. And if it's okay, sir, I would like to address the last question as well. I think that we can all agree that the federal government does have some role to play in affordability, but it's not the federal government that sets our income tax rates, that sets sales tax rates, that creates rules and regulations, competing rules and regulations from different agency departments that are passed on to the homeowner and make homeownership difficult. It's not the federal government that doubles registration fees. So while I think that we can all agree there is some role to that, the chickens come home right here And this is where we need to fix this. And this is where we should be taking this special session to address the affordability crisis that is currently facing all of our citizens, the folks that elected us to solve their problems.
Yeah, I totally agree. I was just making the point that you can't gerrymander a whole state. And when you don't gerrymander, in the last 24 years, we've had 50% Republican, 50% Democrat. But when you do gerrymander, you get a 7-1 map. Now they're trying to get an 8-1 map. But I appreciate the delegate bringing that point up.
Okay, thank you to the panel for your testimony. We're going to move to a new panel of unfavorable testimony. Hear your name: David Morsberger, Robin Ficker, Nicholas Saya, and Douglas Larcombe. Nicholas Larcombe, Robin Ficker, David Morsberger, Nicholas Saya. Let's see. Missing. Okay, I'm going to go through the names because we can fill one. Okay, you're Dave. Dave. Okay, hold on a second. Okay, Dave. I know Robin.
Douglas Larcombe.
Okay, so is Nicholas Saya here? Nicholas Saya? Going once, twice, 3 times. Okay, then we're going to go to the next person on the list. Kurt Gallagher. Is Kurt Gallagher here? Okay, you're going to be our 4th spot. Okay, not paying favorites, but because he's my constituent, we're going to go with Robin Ficker. Robin, you can start. You're on the up to 2-minute clock.
Maryland legislators, I like your looks, I like your style, and I hope you'll all come and see me in my congressional office on the Hill in a little while. It's a pleasure to be here today. The last time I testified before a joint committee in the legislature was in 2007 when I testified against increasing the Maryland sales tax from 5 cents to 6 cents. And who led the opposition to my point of view? Progressive Maryland. They wanted to increase the regressive state sales tax. So when I think of Progressive Maryland, who testified earlier, I think they want to treat the voters like an ATM. I look at the language that we have now, which says each legislative district shall consist of adjoining territory, be compact, and of substantially equal population. Due regard shall be given to natural boundaries and boundaries of political subdivisions. What's wrong with that? That seems like a very good idea. Why don't we put that on the ballot and just say, for congressional districts, these parameters will hold? I'm very concerned because I've seen a lot of projected maps of District 6 where I'm running for Congress. And each one of these districts shows, each one of the maps that I've seen, either put forward by the media or by the Democratic legislators, each one of these maps shows 2 things. One, it shows that eastern Frederick County, where the farmers are, and I see Senator Gallion.
Mr. Ficker, we're up past the 2 minutes, so you got to wrap up.
Okay,
Yeah.
I see that eastern Frederick County is lopped off, but on the western side, it goes down to Congresswoman Delaney's 16-bathroom house. We don't want to change our district. We want to protect the farmers and protect the conservatives of Western Maryland and keep them in the 6th district. Thank you.
Okay, thank you. Sir, right next to Mr. Ficker.
Madam Chair Wells and Senator Feldman and members of this committee, thank you for our opportunity to testify. My name is Douglas Larcombe, people of Maryland for Douglas Larcombe governor. In the primaries, I was running to be the governor of your state. The computer models showed that I would win against Wes Moore. Unfortunately, the Republican Party did not select me. I urge each and every one of you, because of your sworn oath to uphold the laws of the state of Maryland and the United States, to reject this proposal because it violates the law that your General Assembly voted for while it was signed into law by Governor Westmore et al. On May 12, 2026. This new law went into effect June 1st, 2026. This law was set forth via Chapter 439 of 2026 as it pertains to Election Law 7-103C related to Senate Bills 29. Does Westmore not know what he signs into law? Does Ferguson and Melnick not know what they sign into law? 7-103C now provides that on or before July 1st, preceding a general election, the Secretary of State shall prepare and certify to the State Board of Elections questions to be placed on the ballot. The word shall in the state of Maryland law explicitly means mandatory. As a matter of law, in fact, of July 1st of the general election year, the Secretary of State has no statutory authority to certify newly created questions to be placed on the ballot for the general election of the same year. Furthermore, Election Law 7-103C once again conveys the State Board of Elections shall prepare and certify the questions on or prior to the July 1st deadline of the year of the general election. The State Board of Elections Administrator does not have statutory authority to authorize any questions for this cycle because July 1st, 2026 has already passed. Within Election Law 7-103 and Chapter 439, 2026, there is no relief within the statute that includes, with no exceptions that appear, nothing states unless the General Assembly meets in special session, nothing states unless constitutional amendment is passed after July 1st, nothing states unless the governor declares emergency.
Sir, if you could wrap up.
Oh, yes, I can.
Past the 2 minutes.
All right, so most importantly, let's see, in summary, by your committee and the body of the General Assembly for the purpose of adding the question is frivolous, thus moot, because it violates election law. And if I may indulge, Speaker Melnick sat here and, like did David Copperfield, and made the elephant in the room disappear. She said there's this little amendment within your amendment which changes the law that you all passed.
Okay.
And I say explicitly it is important that you vote no on this because it violates law, and I can bring lawsuit for this purpose.
Okay, thank you, sir. Let's go to the next witness.
Good afternoon, everyone, and thank you for the opportunity to testify today. My name is Kurt Gallagher. I'm a lifelong Democrat. I'm a resident of Clinton, Maryland, and I'm here actually to speak in opposition to HB 2100. The reason why is because these bills would undermine the fundamental principles of representative government. I'm appalled, like so many in this chamber, by what Texas and other states have done to gerrymander their districts and to rig the election results. But if we condemn gerrymandering in those states, how can we embrace it here, as in Maryland? I'm reminded by a saying my father told me many times growing up: 2 wrongs don't make a right. The purpose of elections is simple, so we know the will of the people and we can elect office holders to reflect that will. In 2024, more than 1 million Marylanders, or 35% of voters, supported Republican candidates for the United States House of Representatives, yet only 1 Republican was elected to the House from Maryland. And this bill, if passed, if the amendment is passed, we can see where it's going, would authorize the legislature to reduce that representation to 0. If Maryland withdraws its congressional districts as envisioned, what would be the purpose of even holding a general election for House seats? In this moment, Maryland should double down on democratic principles, not undermine them. Attached to my testimony are ideas about how to make our union more perfect and our legislatures more representative and inclusive. I'm forming a new national nonprofit to advance those ideas. I want to leave you with a thought from Dr. Martin Luther King that I think is telling in this moment. He advised, "Darkness cannot drive out darkness. Only light can do that." My fellow Marylanders, I challenge us all to be the light. Thank you.
Okay, thank you. To our final witness on this panel.
Okay. Hello, I'm David Morrisberger from Anne Arundel County. I'm here in opposition of HB and SB 2100. I have testified many times on policy, and this is over the top, as demonstrated by the earlier testimony. I'm sure you all have heard the saying, power corrupts and absolute power corrupts absolutely. One wonders what you dreamed of when you were learning civics, getting your university or law degree, or running in your first campaign. Did you say, my goal in life is to disenfranchise upwards of 50% of voters in Maryland using legalese? Or my goal is to represent or be a puppet to the party over the residents of Maryland? I mean, we all know how the party works in Annapolis. It does make you wonder, what's next, what will the party demand next? There's an old saying, watch what they do, not what they say. Folks are either lying or uneducated when it comes to gerrymandering in Maryland. It's not about Texas or Tennessee or any other state. Let's talk about history. It is about the maps. In 1990 census, it was 4-4. In 2000 census, it was 6-2. 2010, it was 7-1, where a federal judge said it was a broken wing pterodactyl. In 2020, it was going to be 8-0 until a judge overturned it. Now in 2026, you are looking for a way to make 8-0 happen. It's like it was planned incrementalism, perhaps thinking no one will notice. It is clear many believe the end justifies the means. When a judge in the Maryland Constitution get in the way of absolute power, the remedy is to use the supermajority powers to change the Constitution. Only politics in Annapolis would call that clarifying. But sorry, I don't need this body to clarify for me what is a legislative district, given we have both state and federal legislative bodies. This makes me sick and embarrassed to call Maryland my home. It's no reason there are Democratic migration out of Maryland. Beware of the Curley effect. It will sound very similar if you look it up.
Okay.
It is under your watch. My final word then.
Okay.
As my old school Democratic parents have grilled into me and my sisters, just because you can do something does not mean you should. I think you all should take that advice and request that you vote no on HB SB 21.
Okay, I want to thank the panel for their testimony. Any questions from members? We'll start with Senator Carrozza, then we'll go to the House side.
Thank you, Mr. Chair. I'll be brief. And Mr. Daugherty, this question's for you. Because you mentioned that you're a Democrat, and I believe that your voice is representative of at least many Democrats that I'm hearing from in my district. And I represent the Talls family in Crisfield, Maryland, and received an email from one of the cousins of Governor J. Millard Talls. And he pointed out, as you well know, Governor Talls was a lifelong Democrat, and he was pointing out that in his family that, they strongly oppose this effort changing the Constitution, and again, for fair representation. Do you believe that you're representative of other Democrats either in your area or across the state?
I like to think that we really do value diversity and inclusion, and that maybe we're getting a little off, losing the sight of that. I mean, I get it, the desire to fight back, seeing what's happening in Texas and Tennessee, it's infuriating. But I think we need to rise above it and make sure that we really put our values forward and do include people and make sure everyone does have a seat at the table, not shutting people out. And in fact, we're not just talking about two parties. I mean, how many Green Party candidates and Libertarian Party candidates or Democratic Socialist candidates, maybe they shouldn't be part of the Democratic Party, are in this legislature and Congress? None. They should be. They should have a seat too. And that new nonprofit I'm talking about forming would give more voices to more segments of voters. So yes.
Thank you.
Delegate Tomlinson.
Thank you, Madam Chair. This question is for Robin there on the end. I believe you served here in this body a couple years ago, right?
You say, did I serve here?
Yeah, didn't you? You were in the General Assembly.
I was a proud member of the Maryland House of Delegates. Everyone knows that.
Yeah. Can you, and you've been politically active for decades, can you tell us how you've seen our congressional districts and legislative districts change over the many decades that you've been politically active, going back to your time serving, and just how much things have changed?
How have things changed? Well, I can tell you one thing that's changed in Western Maryland is that the big companies, the job providers that everyone needs, has moved out. Just a couple years ago, Nucor Steel, the largest steel company in America, made the biggest private investment in West Virginia history, building a plant that makes sheet metal and rebars that are used in data centers across the country. That plant should have been in Maryland. And if we had focus, instead of using Western Maryland as the tail on the dog, we could have made it the big dog and brought in that huge employer. That's what's changed, and we need to reverse that trend.
Thank you.
Okay, thank you very much to this panel. Thank you very much for your testimony. We'll move on to another panel of unfavorable. I have Ian Chen, Valerie Farrell. Is Christina Bowman with us? Christina, are you here? Okay. Okay, she is virtual, just said both. Cassie Manning and David Whitney. Okay, if Cassie Manning is not here, Nelda Fink. I see you, Nelda. All right. And we will begin with Mr. Ian Chen. You have 2 minutes, up to 2 minutes.
Thank you, Madam Chair. Good afternoon. My name is Ian Chen. Just over 1 year ago, Tamika Good and Corey Pollard began their squatting occupation of a $2.3 million mansion next to my childhood home in Bethesda, Maryland. My community experienced firsthand what happens when our government fails to respond to real challenges that affect everyday Marylanders. Marylanders are worried today about housing costs, safety, education, and affordability, and they're worried whether someone will invade their homes without their permission and without their knowledge. Our Constitution should not be changed simply because we can change it. It should be amended only when it is absolutely necessary to do so, and this amendment does not come close. Maryland communities deserve districts that reflect their shared interests and their values, not maps manipulated to favor one party or to protect incumbents. Every hour that this committee and our General Assembly spends debating a constitutional amendment that does little to improve the daily lives of Marylanders is an hour not spent addressing the challenges that truly matter. Good governance is measured by how much you can impact your constituents and how you can improve their daily lives, not how much you can tip the scales of the U.S. House of Representatives. The people of Maryland do not need a government that spends its time reshaping political maps. They need a government that protects their homes, that strengthens their communities, and solves the problems they face every day. I respectfully ask for an unfavorable report on this amendment. Thank you.
Good afternoon. My name is Valerie Farrell. I'm an attorney. I live in Cecil County. I'm also on the Republican Central Committee, but I'm here on my own behalf today. I'm here in opposition to these bills because it could fundamentally weaken long-standing constitutional safeguards that were designed to protect Marylanders from partisan manipulation of congressional districts. With my limited time, I'm going to focus on the very troubling concentration of judicial review. If we vest original jurisdiction over congressional redistricting challenges directly with the Supreme Court of Maryland, the bill bypasses the ordinary judicial process that has long protected the integrity of the constitutional litigation. The types of issues the Supreme Court has original jurisdiction over is very narrow and typically focuses on difficult procedural postures, like when states are suing states, and things concerning the integrity of the legal profession, like attorney discipline. Trial courts exist for a reason. They develop factual records, hear expert testimony, make findings of fact, produce written opinions that sharpen the legal issues before appellate review, and they can issue preliminary injunctions so that permanent harm is not done to people while they're waiting for the litigation process. Eliminating those steps means fewer factual findings, fewer judicial perspectives, fewer procedural safeguards before the state's highest court decides issues affecting every Maryland voter. And it politicizes redrawing maps because of the fast-tracked nature of the situation. As an attorney and a policy analyst, I have been seeing a concerning trend in legislatures across the country of removing procedural safeguards for citizens when they want to challenge government actions. Rather than simply changing substantive law, governments are increasingly changing the procedures citizens must use or eliminating them entirely to challenge this action, whether through restrictions on judicial review, limitations on evidentiary development, or grants of procedural immunity. The effect is the same. There are fewer opportunities for citizens to obtain a full and fair hearing. For all of these reasons and more, I respectfully request an unfavorable report on both of the bills.
Thank you, Madam Chair. I'm Pastor David Whitney, Senior Instructor at Institute on the Constitution, the only place where the Maryland Constitution is actually taught as a course, and I am the instructor of that course. I oppose this bill for numerous reasons, but let me mention the first here, that the language of this bill, particularly what's going to appear on the ballot in November, does not speak the truth. It refers to federal applicable laws without telling us what those laws are. When you research the Congressional Research Service and query them, you find out that this is all that exists: Equal Population and Voting Rights Act. As has been pointed out already, that may have been gutted by the decision in Louisiana. So compare that to the additional protections provided by our Maryland State Constitution over a long period of the history of our state: adjoining territory, compact form, natural boundaries, and political boundaries. So honest ballot language would say this. It would tell the voters, if you vote for this amendment, you're going to be eliminating the following criteria of adjoining territory, compact form, natural boundaries, and political boundaries by voting yes for this constitutional amendment. You should also include on the ballot a picture of this. This is that pterodactyl broken, as someone has called it, the worst gerrymandering in the history of this constitutional republic, that puts an embarrassment on the state of Maryland. And I know personally what this is like because I lived in this district, and I still live in this district, 30 years plus in this district. My vote was diluted by this sham of a redistricting. And if this amendment passes with those in the state of Maryland, this will become legal. That's why you ought to put this on and say, you're voting for this if you vote for this amendment. We do not need to be the laughingstock of the nation any longer. I ask that you scratch the language that is currently proposed for the amendment and put this language in its place, which would clarify, and there's a lot of talk about clarification.
5 seconds to wrap up.
This would clarify exactly what it is that you need to have. That the criteria for congressional districts shall be the same as for Maryland legislative districts. That would answer.
Thank you very much, Mr.
That would solve the
Whitney.
problem.
Your time is up. We will move on next to Ms. Nelda Fink.
Nelda Fink, District 32. Good afternoon, legislatures. Thank you for the opportunity to speak out in opposition against this whole unlawful process. Yes, it is an unlawful process, as you have not followed the very statutes you yourselves have enacted. My written testimony details the legal and procedural defects, and I ask every member to read it. Article 2, Section 16 permits the governor to convene the legislature only on extraordinary occasions. Yet the proclamation identifies no circumstances arising after the regular session adjourned in April, and 4 regular sessions have passed since the 2022 cases cited in the bill. The state waited 4 years, then gave Marylanders only 2 business days to respond and 1 10-hour window to register and submit testimony for a hearing held the same day this bill was formally being introduced. This is not an unavoidable emergency. It is an artificially compressed political process designed to place a predetermined constitutional amendment on a November ballot. And what are Marylanders being rushed into approving? A proposed Section 62B declaring nothing anywhere in the Maryland Constitution, including the Declaration of Rights, provides applicable criteria for congressional district boundaries. This is not a clarification. It's a removing of the Maryland Constitution from the congressional redistricting process and preventing our courts from applying state constitutional protections to those boundaries. Understand this. We see what is happening. You cannot manufacture urgency by refusing to act for 4 years and then use that self-created deadline to deny public scrutiny of a permanent limiting amendment to our Constitution. Our Constitution exists to restrain government and protect the people, not to be rewritten through political expediency whenever its restraints become inconvenient to those in power. Representation is not meaningful when the majority uses its numbers to silence the minority and remove constitutional safeguards against itself. The body should reject the SB 2100 totally and without amendment, and follow the rules by introducing it during a regular session. And I respectfully request an unfavorable report on SB 2100.
Okay, Senator West.
Thank you, Mr. Chair. A question for the fellow who teaches constitutional, the course on constitutionality. So as I read the bill, and I appreciate you've read the bill, I want you to confirm. My impression is that you could take 10 Republican precincts in northern Baltimore County and include them in the 8th Congressional District in Montgomery County, because the contiguity requirement is being eliminated. You could take 10 Republican precincts in Washington County and include them in the 4th Congressional District in Prince George's County. You could take 10 Republican precincts in Worcester County and include them in the 7th Congressional District in Baltimore City, if this bill is enacted. Would you agree with that?
Yes, I would exactly agree, and the history of this broken pterodactyl proves that. There's one section of this broken pterodactyl that is an island. That is, there's a road connecting it, but down the center line of the road is the only part of the district. No house on either side of that road belonged in that district.
But under this proposal,
This would be legal.
you wouldn't even have to have that. I think it was an alley. It wasn't a road. It was an alley in
An alley,
Baltimore
yeah.
City. You wouldn't even have to have the alley. You could take completely separate
Yes,
areas and put
exactly.
them together, even though there's no connecting tissue whatsoever. And if somebody wanted to complain about this under this bill, the Supreme Court of Maryland would have no standards they could use.
Exactly.
And if you went to the federal courts to try to argue that this was unconstitutional, the only standards the federal courts have are equal population and the rights bill.
And that's exactly true. So
And neither of those standards would impact what's going on with the failure to keep districts contiguous.
exactly. And so
Thank
my
you.
question is, what's wrong with the standard that we already have for the legislative districts of the state? Why don't we just apply that standard to the federal districts for each congressional district? It's a good standard. Why get rid of it for the national venue rather than just restrict it to the state legislative
Thank you
districts?
for your answers.
Thank you.
Thank you very much. Delegate Tomlinson.
Thank you, Madam Chair. Questions for the individual in the far corner there. I think, did you mention something about squatting? Yeah, I think I
Yes.
recognize you from some different articles. I know you only have 2 minutes. Can you just kind of, what were you talking about?
Yes, I've been a part of a ongoing legal dispute with squatting in our state that started next to my childhood home in Bethesda, Montgomery County, Maryland. I think Senator Watson's here. We worked on a bill to close some of the loopholes, but there are still plenty more that are out there, especially with vacant and bank-owned properties. And I just feel like that could be a better use of the General Assembly's time rather than talking about potential maps and redrawing things when we can focus on some issues right here in our own home.
Gotcha. All right, thank you.
Thank you. All right. Thank you very much to the panel. We'll move on to our next.
Okay, we're going to go to another panel of unfavorables. We're almost getting towards the end here. Amy Leahy, Hunter Pettit, Liliana Norkaitis, and Maria Sophia. 4 witnesses. Heard your name. Come on up. Okay. Okay, we'll start to my left. Your mic is on. Tell us who you are, and you're got up to 2 minutes. You're on the clock.
Thank you, Chairman Feldman. Chair Wells, Chairman Feldman, members of both committees. For the record, my name is Maria Sophia, and I'm an Anne Arundel County resident that would be directly impacted by this mid-cycle redistricting, and I'm here to urge an unfavorable report on HB 2100. Maryland is a majority-minority state. If congressional lines were drawn with impartiality, it would be inevitable that 1 or even 2 districts would be majority-minority simply based on our population makeup, and that would not violate the recent Supreme Court Calais decision. But the proposed map is susceptible to a Calais-style challenge. I bring this up because recently the House of Delegates has passed this map, and this is also the map that has been discussed by the governor that would go into effect if we were to redistrict. The proposed map splits Baltimore City into 3 congressional districts and Anne Arundel County into 3 as well, dividing historically Black and African American communities across all 3. It also splits our Hispanic communities, placing Highlandtown in southeast Baltimore in 1 district, and Parkville on the northeast side in another. In Anne Arundel County, our Black and African American communities are similarly split. In Brooklyn Park and Annapolis, they fall into 2 different districts. Our minority communities in South County are also placed in the 3rd district. Beyond splitting communities, the map also packs Crisfield and Columbia into the same district, two communities with very different economies. The Eastern Shore should stay in a district that preserves its shore way of life, and Columbia should stay in a district that strengthens its growing urban economy. Mid-cycle redistricting also carries long-term costs. It weakens representation and constituent services, it causes voter confusion, and forces every local board of election to spend money re-educating voters when lines change. It's simply bad policy. If it's wrong in Texas, it should be wrong here in Maryland. I respectfully urge an unfavorable report. Thank you.
Okay, thank you.
Hello, members of the committee. My name is Liliana Norkitis. I live in Harford County, and I am here today to urge an unfavorable report of HB 2100. Our state constitution serves as a protection for Marylanders, declaring that our districts, both legislative and congressional, be compact, contiguous, and maintain natural boundaries and communities of interest. The framers of this provision ensured that Marylanders would be represented by leaders who understand their interests and the communities they serve. Removing the application of this framework to our congressional maps will trigger the most egregious gerrymander this state has ever seen. Calling this special session in the middle of the summer to debate rewriting the very fabric of our state's republic is appalling. Marylanders are experiencing the perils of living in a state with low energy production and overtaxation, yet this body thinks that the most pressing issue to Marylanders is to eliminate the protections that ensure fair congressional representation. Our state has had a long history of partisan gerrymandering, and it has earned us the ignominious national representation as one of the most gerrymandered states in the country. By eliminating the guardrails that ensure our congressional districts are fair, we will continue to carry that scarlet letter. This legislation was published just a few short days ago, and Marylanders have had very little time to sign up to testify. This process is barreling down a dangerous path, and if we do not turn around now, then Annapolis has lost its moral compass and forgotten the charge that weighs upon each of you to leave this state and its people better than you found them. By indulging the selfish desire for partisan and personal political gain, you will leave Marylanders behind to suffer the consequences. We, your constituents, are more than mere stepping stones upon that primrose path to Washington that so many of our elected officials seem so eager to take, and it is time that we are treated as such. I again urge the body to reject HB 2100 because our state constitution is worth upholding. Thank you.
Good afternoon, Chairman Felder, Chair Wells, delegates, and thank you so much for the opportunity to speak. My name is Hunter Petit, and I am a private citizen. I'm a proud, lifelong Marylander, and even prouder to be from gorgeous Prince George's County. Being here in Annapolis is personal to me. It was on the grounds of this General Assembly that I first fell in love with politics and public service as a state page on the Senate side, representing Prince George's County, which is why today is painful for me. I'm not here to reminisce. I'm here to ask you with immense love for the state that we all call home. Please do not rewrite Maryland's Constitution to make gerrymandering easier and to remove our rights as Marylanders. Please do not. Maryland once had some of the worst congressional districts in America, and it was a national embarrassment. I'd like to think that all of us were proud when our state began to move away from that legacy. Please do not send us backwards. Yes, Maryland is a deeply democratic state. And yes, other states are drawing their maps to entrench their power. But I know that all of you know, deep down, that you cannot defend democracy while you're actively undermining it. Your responsibility and the oath that you swore is to the people of Maryland, not to national political leaders. That includes Republican Marylanders. They are not your enemy. In fact, many could argue that Maryland has more to lose than any other state due to swings in federal policy. Presidents come and go, and it would be unwise for a state whose economy is so deeply tied to the federal government to never have anyone on the other side of the aisle fighting for us in D.C. If you want the economic hardship that we have experienced over the last 2 years to become a recurring event, this is one way to guarantee it. And here's the harsh reality. Creating a more aggressive gerrymander of Maryland doesn't just dilute GOP votes. It requires cracking black communities across Prince George's County, Charles, Baltimore City, and everywhere in between. As a data analyst by trade, I'm not here to speculate. I'm here to tell you that that is simply the math. You're being told that you must fight fire with fire, but our American democracy is not a fire. It is not something that you torch in flames because someone else lit a match. It's something that you protect, even when it's difficult, even when it's unpopular, even when your party's telling you to do something else. It's something that you protect no matter what. So please do not disenfranchise our Republican Marylanders. Please do not destroy the voices of our black communities, and please do not rewrite our Constitution for a temporary political advantage. I welcome your challenging questions. Thank you.
Good afternoon. My name is Amy Leahy, and I am surprised I'm called up here because I never got an email. Anyway, so I'm going to wing it. I'm actually a resident of Anne Arundel County, and in District 33, which is the area I live in, it was predominantly a Republican district up until, I don't know, 8 years ago, 4 years ago, when the legislature decided to redistrict. So we had a state senator, Ed Riley, who had been in that seat for about 14 years. We had 3 Republican delegates. In the time after the 2022 census, we've actually had changes. So now we have only 1 Republican in that district, and that is Delegate Stu Schmidt, sitting right over here. So I just want to say that the redistricting, when you give Democrats a chance, they will do it, and this is exactly what we're looking at when it comes to trying to get rid of Andy Harris over on the Eastern Shore. So my husband actually wrote out something for me, which I'm going to take a chance and read a little bit of this. SB 2100 runs directly counter to public opinion, both nationally and within Maryland. Nationally, with the bipartisan polling, consistently demonstrates that roughly 80% of Americans, spanning Democrat, Republican, and unaffiliated voters, oppose partisan gerrymandering and favor drawing districts through transparent rules that emphasize compactness and community preservation. Just as an aside, District 33 now consists of, starting at the Chesapeake Bay on the Broadneck Peninsula, all the way through Arnold, Severna Park, only half of Severna Park, and then it goes into Crownsville, Crofton, Odenton, down to Davidsonville, and that is not an area that is compact or addresses the concerns of residents who are in each of those different communities, like a farming community, and then you've got the Chesapeake Bay, and you've got suburbanites, and you've got federal workers who are out there in Odenton.
Okay,
I
so
guess that's
you're
it.
going to have to wrap up.
Thank you.
Okay, thank you. Questions for this panel? Senator Simoner.
Thank you. Thank you all for coming. I don't know if you know, I'm retiring, so they called me back in for this wonderful session. I was off riding a horse and they pulled me right off. Some said it was a scooter, but anyway, I have a lot of friends down here, and historically I've worked with Democrats. I've voted with Democrats when none of my Republicans voted with me. I always look to see what the best bill was for the people. And you can go back and look at my record and you'll see that. In 2021, I was the minority leader, and I got called into a listening tour for redistricting. And it broke my heart because I heard people say, you can't gerrymander. It hurts Democrats, hurts Republicans, hurts independents, and I knew they weren't going to listen to them. And we came back, and sure enough, we passed the maps. And unfortunately, I've been down here 20 years. I know that all your testimony, and the majority of you are against it, literally is going to have zero impact on the outcome. So one, I want to thank you for taking your time coming down here, even though they're not going to listen to your voice. They'll listen to it, but they're not going to take any action on your voice. When we're called into special session, it's scripted. They know they have the votes. They know what they're going to vote on. They're going to get in, get out. That's what's occurring here today, and it breaks my heart because we are here to represent the people, first and foremost, not a party. So, Amy, I'll just direct it to you. We hear a lot about democracy, and how does that make you feel when they're putting a scripted special session, allow you to come down, and then afterwards, and the press, you can look at it, see if any changes were made based on all this testimony when we're done, because it's going to be scripted, and they already know the outcome.
Senator Simoner, I know exactly what you're talking about. I've never run for office before. This is my first time. I have, however, been very involved in the political drama, the realm, ever since I changed parties from Democrat to Republican, and that's been 25 years now. But I have to say, I know exactly what happens. I know what to expect. You become very disenfranchised as a Republican. You're just very discouraged and disenfranchised, and it's very hard to get Republicans to get out and vote in this state of affairs that we have in this state right now. But we have to stick to it. We have to just keep trying.
Chair Wells, do you want to go over here, or you want to stick on this? Okay.
Absolutely.
Go.
Delegate Tomlinson.
Thank you, Madam Chair. This question's for Lily. Known you for a long time, can't remember all the titles you've had, but I mean, I often look at you as, you know, one of the more active, young, conservative voices out there in the state. Can you comment a little bit on, I mean, both parties struggled to get young folks motivated to not only vote, but also to be active and to participate in the whole process. Can you talk a little bit about how you think this constitutional amendment is, well, you can answer however you want, but I mean, in my opinion, this constitutional amendment is going to do nothing more than just continue to discourage young folks from participating. Can you comment a little bit on that?
Yeah, absolutely. And it's funny you say that, actually, because the witness next to me I met through political activities in college. So I know in me being involved, I've gotten a great network of just some great young people who truly care about this state and want to see a better path forward for our generation, for our kids and our grandkids, because this state is worth saving. I do think that this amendment will hinder some of our young people's ability to really just be involved and participate. For example, I've done several internships on Capitol Hill. I personally would not have picked some members of Congress over others to intern for, but just specifically in that instance of students who want to engage in the process and work for someone who they might agree with. That alone is going to be harder. I also think that if we are going to have districts that are far less competitive, there are going to be far less teams of volunteers, far less teams for campaigns, and it generally is harder to get younger people interested in a process that you already know what the outcome is going to be. But yes, I've loved every second being involved in the government and policy space, and I hope to continue to fight here in Maryland because, again, as I said, the state is worth saving and the Constitution is worth upholding.
Okay, let's go Senator Washington.
Thank you, Chair, and thank you all. I wasn't going to speak again, but I just want to offer just another perspective of this gathering. You know, a lot of us ended family vacations, left our workplaces. This is very important. So I assure you that none of us would stop our jobs, you know, withdraw some family obligations. I was in a family reunion in South Carolina, left early, arrived here last night at 11 so that I could be here to participate in this. This is very important. It's always important. I think an indication, if I might just be allowed a little flexibility, is that we are not voting on a map. That was very clear. There was some disagreement. There was people that supported it and people that didn't, and there was very clear, I would say that was an influence that you would see that in this amendment, this constitutional amendment, that it does reflect that the legislature did hear clearly that we were not in a position to change our Constitution specifically around a particular map, right? We also are seeing that in this discussion, we have individuals that support part of it, the idea. We have individuals of the same party. You had the House party members supported a map of a party, and members of the same party did not support the concept. So I want to, again, strongly affirm that from my seat, and I think from many of us, that your voices are heard, and that because one is a Democrat or one is a Republican does not predict necessarily how one is going to vote. There is still, we're individual districts, yeah, that's just what, and I appreciate being able to say that because this is a very important process. Voting is very important, and you should always fight. And coming from a category of a person who ancestors were owned at some point, a woman, we're not allowed to vote. We were not in this chamber. I could not marry the person I love in this state 15 years ago, that think that we as a state do move with the times and we move with our people
but we move so carefully and slowly. So thank you, Chair, for that consideration. Allow me to just make that statement to affirm to these folks that everybody here, your voices are heard. It matters that you're here today. Thanks.
All right, thank you. We will end from our side with Delegate Schmidt.
Thank you, Madam Chair, and I want to say thank you to the panel. It's great to see some young faces really standing up for democracy and for the Republic, so I appreciate you being here. As the representative that probably represents the fairest map in the state, I've taken a lot of notes, and I've heard words of clarity, parity, same set of rules, and that this, I guess, amendment is going to be straightforward. Aside from my personal beliefs about that, I do have a question for Maria Sophia regarding what you brought up regarding how these maps and how this amendment will change voting and disenfranchise a large subset and a large series of voters in our state.
Thank you, Delegate Schmidt, for the question. With regards to the map that you're referring to, it does divide Anne Arundel County up into 3 different congressional districts, and it does the same for Baltimore City, like I said. But I think one of the parts that I didn't talk about was particularly in Baltimore City, the census tracts that are directly above Johns Hopkins University are in one congressional district, and then Johns Hopkins University and the southern part of Baltimore City are in another, which I think is interesting because you're also dividing up a university community as well, and our students. But you see that honestly across these congressional districts, the way they're drawn. But I mean, for the purposes of today, I mean, my sincere hope is that, you know, that we continue to have, you know, an approach to redistricting in the future that is nonpartisan. I mean, 6 years ago, Governor Hogan proposed maps with an independent commission and even had legislation attached to it, where if we would have passed that legislation 6 years ago, we wouldn't be sitting here today because we would have had that approach going into the 2030 cycle. So
Thank you for that. And yes, Amy, I do consider you a young person as well.
thank you.
Okay, let's, I think the final 2 witnesses for this panel will go Senator West, then Senator Carrozza. You'll have the final question, okay? Senator West?
Thank you, Mr. Chair. First of all, for Mr. Petit, during my years in the General Assembly, which are coming to an end, because I'm, like Senator Salmonair, not running for re-election, the past 12 years, one of the glories of this body, I think, has been its pages. And I've taken special efforts during my years here to get to know the pages, invite them back to my office and say, come on, let's talk about how the place really works. So let's kick the ball around the wall and have an interesting conversation. And many pages have taken me up on it. I want to say, as a former page, I thought your presentation today was far and away the best of anyone.
Thank you.
It was quietly passionate, and it was incredibly eloquent. So I want to compliment you and encourage you to keep up your interest in public affairs. Ms. Sophia, when I had my example a couple of minutes ago of coupling Worcester County Republican precincts with the 7th Congressional District in Baltimore City, I was just making it up. But now you talk about a map. Was this a serious map that you saw that somehow coupled Crisfield with Columbia?
Yes.
Because frankly, the distance between Crisfield and Columbia is at least as far as the distance between Worcester County and Baltimore City. And you actually saw a serious map which purported to do that.
It actually was the map that would, the governor's redistricting commission map that was passed that would make the 1st congressional district come across the bridge and do that. It goes all the way up to Columbia, yes.
Wow, okay. Well, so my hypothetical example a few minutes ago actually turns out to be not quite so hypothetical, does it?
No, Senator.
Thank you.
Okay, Senator Carrozza, final question for this panel.
Thank you, Mr. Chair. I want to thank each one of the panelists and those who testified prior to this panel. Thank you. You've taken time out, you've been patient, and we are listening. And you've come with ideas, and you've pointed out, you've pointed out reasonable objectives of why you're opposing this legislation and this change to Maryland's Constitution. My question is to our former Senate page from Prince George's County, since you gave the opening about challenging questions. I don't think this is so much challenging, but maybe following up on Senator West's remarks. You seem from your presentation and having the benefit of seeing the Maryland Senate in action, where we do work across party lines, and we are very effective and sensitive to the different areas, whether I represent a rural area and somebody's coming from a city, like my seatmate in committee. But so my question to you is, you seem to understand that as proposed with this constitutional amendment, you could go to that 8-0 map, which in effect eliminates voices, and then therefore you're moving to that solid one-party power in the state of Maryland. And yet you've also seen the benefit of when we have a, more of a balance. Can you further elaborate on that?
Sure, yeah. I think that, obviously first, and I kind of, pointed out in my discussion here, but the fact that Maryland's economy and, so much of our way of life is so connected to the federal government, it wouldn't just be unwise, it would be kind of silly for us to never have anyone on the Republican side who's fighting for us in D.C. I think, you can like Andy Harris or not, but I think that his constituents elected him in a district that, everyone has a fair vote. And if you would like to get rid of him, there's already a process for doing that, whether that's the Republican primary or the general election. And since those processes, I guess, are too difficult, I guess we're going to go this route, but I don't think we should change the Constitution to do that. And then to elaborate on Liliana's point in terms of political participation of young people, because I was a page, and it was being a Senate page that grew my love of politics, and a number of people here I was there, and it's so cool seeing them here today, which is why it is painful, because I looked up to them, and I'm it's kind of a letdown to see, I guess, political gamesmanship take over lots of people that I thought, and not to impugn anyone's integrity, but it's just been very interesting to see. I think that most importantly, everyone in Maryland should have the right to choose their representatives. Representatives should not be choosing their constituents. We've been through this many, many times, and I've expanded many, many times in my speech. Black and brown communities, in addition to Republican voters, are going to be the ones who will be the losers in this battle, just so that we can get rid of one congressman. And I think that that's unfortunate. I think it's sad. And I think it is something that's going to dilute not just the votes of those who don't agree with the majority, but dilute political participation, especially amongst young people, who the biggest group of young people rising up, not just in Maryland, but this country, they are independents. We have a closed primary system here. They already can't participate. And we're basically saying here, all of our congressional seats in those elections, they're going to be predetermined. You don't actually have to come out and participate unless you choose to become a Democrat, and then you can join in the Democratic primary. But if you don't make that decision, then ultimately, what recourse do you have? You don't really have any, unfortunately.
Thank you.
Thank you.
Okay, I think thank you all for your testimony. I'm going to turn it to Chair Wells. I think we have one final panel of in-person witnesses, and then I believe for the benefit of the the two committees, I think we have about 8 virtual witnesses in the queue, but we have one more panel of in-person, so Chair Wells, why don't you call them up?
Thank you very much, Chair Feldman. So we have one unfavorable for this panel, Nicole Harris, 2 informationals, Nancy Soring, J.C. Nuringer, and I want to go back because I believe we are joined now from the favorable panel with Daryl Jones, if he's still here with us. So we will have Ms. Nicole Harris, she'll speak first, we'll do the informational, and then we'll finish with Mr. Jones.
Thank you. Thank you, Chairman, and to the members of the Joint Committee. I'm Nicole Buse-Harris. I'm a resident of the Eastern Shore, and I am also the chairwoman of the Maryland Republican Party. Here we are to discuss a constitutional change to how and when congressional districts are mapped in the future. I've submitted a written statement, but I want to highlight a few points. First, I believe that gerrymandering is wrong, no matter who is drawing the maps. It doesn't give a balanced representation to the residents of a state, and it can dilute the voices of communities. Whether gerrymandering is done by race, occupation, urban, suburban, rural, or by political party, it doesn't matter. Diluting the voice and representation of any citizen within the state is wrong. Second, I believe that congressional districts should be drawn based on the same criteria that has been codified for our state, Senate, and delegate districts. Districts should be drawn for like communities with respect to geographical boundaries, and they should be as compact and contiguous as possible. Allowing redistricting at any time will take away the only strict foundation of the current borders for congressional districts, that plus or minus 2 people based on the current census and an updated census. Third, making it possible for the state legislature to redistrict in any cycle takes away the stability of our residents. People have a hard enough time knowing who their representatives are and trying to build a relationship with them. Potentially putting people in different districts every 2 years will discourage the average person from engaging politically and from feeling heard and represented. As members of the Maryland General Assembly, each of you should feel responsible to foster growth and interaction with your constituents and to make it easier for leaders at every level to do the same. Finally, if the ability to redistrict is put on the ballot and it passes in November, this will be a constitutional change that will affect generations to come. Everyone needs to remember Senator Norman Stone and how he was redistricted by his own party. If this is changed, it doesn't matter that it's for the Republican right now and to draw him out of the state. It could be used against anyone who is not upholding and pleasing the Annapolis legislature at any given time. So please give an unfavorable report to this bill of HB 2100.
Thank you. Any questions for the unfavorable witness? Okay, seeing none, thank you very much, Ms. Harris. We'll move on to Ms. Nancy Soring.
Chair Feldman, Chair Wells, my name is Nancy Soring. I'm testifying information only on behalf of the League of Women Voters of Maryland. Since 1920, the League of Women Voters has had one singular mission: empower voters, defend democracy. We've overcome obstacles, discrimination, and sins of the past, but we always continue our fight to put voters at the center of democracy, not political parties. I agree with the bill sponsors that our Constitution is silent on the fact of congressional standards. That's why for probably 10 or 12 years I was down here supporting legislation to put congressional standards into the Maryland Constitution. Well, here we are today. But the idea that this is just simply about clarifying that poor decision that was made by one of the judges, it's a blatant step towards mid-cycle redistricting in an effort to get rid of the last Republican district in Maryland. Beyond the short-sighted nature of this bill to simply remove Republican representatives, there are very long-term consequences. These are decisions that can impact Marylanders well beyond the current political climate and this current General Assembly. This amendment comes without a sunset clause, without clear definitions of how future maps should be drawn, and essentially gives whoever is in power a blank check to redo maps before elections as they see fit. I think a sunset clause is something you might want to think about. Through the constant fighting for even more power, Maryland's majority party has forgotten that at the end of the day, it should be the voters who choose to represent them. If you are going to go forward with this, we insist that at least you consider an independent Citizens Redistricting Commission. And speaking of voter suppression, we also feel it's disgraceful that once again, special sessions failed to make it out of this General Assembly. Thank you.
Okay, we have a question from Delegate Thomason. Thank you very much, Ms. Soring.
Thank you, Madam Chair. So yeah, I appreciate that you also believe that our our congressional districts should be created using the basis of compact, contiguous, and equal populations. I mean, is there any reason why? I mean, why should that be good enough for legislative districts but not good enough for congressional districts?
I agree. It should be our congressional districts, and year after year, legislation was submitted to this body to that effect, but it never made it out of committee.
Thanks.
Is that it?
Okay, Senator West. And by the way, several of our members on the Senate side had to go over to the chamber to make a quorum because we're actually in session across the street, but so some of our members did go to the Senate chamber for that purpose. Okay, Senator West, why don't you have the final word here? Last question.
Just a very brief question. I thought your testimony was very persuasive. Are you speaking on behalf of the Maryland League of Women Voters?
Yes, I am.
Okay,
we have supported redistricting reform at a national level and the local level for decades.
Great. Thank you for your presence this afternoon.
Thank you.
Okay, and we have a last question from our side from Delegate Chisholm.
Thank you, Madam President. I think it was just answered, but I wanted clarification too, because I wanted to know if it was the position of the League of Women Voters to have an independent commission.
Yes.
Thank you.
Okay. Thank you very much, Ms. Soring. So with that, that concludes our in-person testimony. We will now move on to our virtual testimony. And I'll begin with our favorable, Hadley Anthony. Not present, thank you. Additional favorable witness, Linda Dorsey Walker. She is present, thank you. Yes, we can. We're going to ask our AV if they could please turn down the microphones inside. But Ms. Dorsey Walker, you have up to 2 minutes to provide your testimony.
Very good. Good afternoon, members of the Maryland General Assembly. My name is Linda Dorsey Walker. I'm speaking for the New Horizons Group in Baltimore County.
Yes, Ms. Dorsey Walker, we can see you and we can hear you. Not quite sure what happened. We're having some technical difficulties. Ms. Walker.
Let me start over.
Okay, we're going to restart your time clock. You have 2 minutes. Just so you know, you may not be able to see us, but we can see you and we can hear you. So you have up to 2 minutes to provide your testimony.
Very good.
We're listening.
My name is Linda Dorsey Walker. I'm speaking for the New Horizons Group in Baltimore County. I'm a 9-term elected member of the Baltimore County Democratic State Central Committee.
Ms. Dorsey Walker, can you hear me?
Yes.
Yes, you have the floor. We can hear you. You can continue speaking. You're providing public testimony right now on HB 2100. Okay.
Okay, let me start. First of all, I chaired. Yes. Yes, I can. And
oh, okay, Ms. Dorsey Walker, if you are listening to the live stream, please mute the live stream. I don't know. Maybe
okay, can you come back to me so I can take the live stream off first? Thank you.
Sure. All right, so we will hold on Ms. Dorsey Walker. We will move to favorable with amendments. Okay, Mr. David Anderson is not here. The next favorable with amendments by virtual testimony is Ms. Margaret Winters. Okay, she is not here as well. Okay, Ms. Dorsey Walker, are you prepared to provide testimony yet?
Not yet.
Okay, all right. We will move on next to, sorry, I think I lost myself here. Mr. Robert Nelson.
Yes.
Hi, Mr. Nelson. If you are listening to the live stream, please close out the live stream so there's no feedback.
Will do.
Thank you. And we can see you and we can hear you. So you have up to 2 minutes to provide your testimony. Thank you.
Am I on now?
You are on, yes. We all can see you.
Okay. Hello, Senator Feldman. It's good to see everyone. I'm Robert Nelson from Goshen, Montgomery County. My grandparents immigrated from Sweden to the United States. My father fought in World War II, was shot in Germany, and was physically limited. And I'm the first one in my family to complete a college education. I moved to Maryland when I was 19 years old and have enjoyed all the opportunities that the free state gives to everyone regardless of family origins. As a former chair of the Montgomery Upcounty Citizens Advisory Board, we always wanted to receive diverse inputs from community residents. The Baltimore Sun asked in a current poll, do you think Maryland should redraw its congressional map before the next census? 83% of the respondents said no. As we've heard many times, the Constitution is pretty clear. Each legislative district shall consist of adjoining territory, be compact in form, and of substantially equal population. Due regard shall be given to natural boundaries and the boundaries of political subdivisions. Well, what does Clarksburg have in common with Cumberland? What does Columbia have in common with Cambridge? I used to be in District 6, extending to Western Maryland, with a history of Republican representation. With political manipulation, I was moved to District 8. With 51.4% of the active voters registered Democrat and 46.7% of the active voters registered Republican or unaffiliated, there should be at least 2 minority party members representing Maryland in Congress. If diversity, equity, and inclusion is broadly promoted in Maryland, then why doesn't it also apply to Republicans and independents? Let's leave no one behind, including Republicans. And as our friend Louis Goldstein used to say, God bless you all. Real good. Thank you for the ability to testify.
Okay, thank you very much, Mr. Nelson. We will move on to our next person, Paul McCosby, excuse me. Okay, Mr. Mick Cosby, if you are there, please turn on your camera.
Thank you. And we can see you, we can hear you. You have up to 2 minutes to provide your testimony. Thank you.
And Mr. Mick Cosby, can you please turn off your live stream of the hearing?
It's good to see everyone. I'm Robert Nelson from Goshen, Montgomery County. My grandparents immigrated from Sweden to the United States. My father fought in World War II, was shot in Germany, and was
Okay. Brigitta Mulliken. Hi, Miss Mulliken. If you could please, if you have on the live stream, please close out the live stream so there's no feedback.
Got it.
Hi.
Thank you.
Good afternoon. You have up to 2 minutes to present your testimony. Thank you for being here.
Okay, I'm up now.
Yes, you're on plate.
My name is Brigitta Mulliken, and I'm a resident of Rockville in Montgomery County. I'm a naturalized citizen, and I respect all the laws of the country. Thank you for the opportunity to testify. You should not amend the Maryland Constitution for mid-cycle congressional redistricting. Please vote against House Bill 2100. I oppose the proposed congressional redistricting because I believe congressional districts should be drawn fairly, transparently, and with the goal of providing effective representation for Maryland citizens, not to benefit one political party over another. Marylanders deserve a redistricting process that emphasizes fairness, transparency, and accountability. Competitive elections encourage candidates to listen to all constituents and help ensure that elected officials remain responsive to the people they serve. Regardless of political affiliation, every voter deserves to have confidence that the congressional districts are created through an open and impartial process that reflects the interest of the public rather than partisan consideration. I respectfully urge the committee to reject the proposed redistricting plan for Maryland's congressional districts and instead make sure the districts are fair, transparent, and representative of Maryland's diverse communities. Congressional districts should reflect the interest of the people they serve, promote public confidence in the electoral process, and provide voters with meaningful and effective representation. Since I waited for 5 hours to listen to you all, I want to thank you for your time. Also, Josephine Salazar, who's a candidate, texted me and she wanted me to speak for her, but I told her I could not do that. She was unable to get her testimony onto this venue. Thank you for your time.
Thank you for your time. We will move on next to, let's see, who is that? Pamela Holtzinger.
my father fought in World War II, was shot in Germany, and was
Okay. Hi, good afternoon, Ms. Holtzinger. If you are listening to the live stream, please close out the live stream before you begin your testimony. You have up to 2 minutes.
Thank you. Can you hear me?
Yes, we can hear you.
Beautiful. Thank you. Good afternoon, Chairperson Wells and members of the committee. I'm Pamela Holtzinger and a Maryland voter from Frederick County. I'm asking you to reject House Bill 2100. This bill asks voters to hand the legislature a blank check to redraw congressional maps again, the second attempt this year after the Senate itself shelved a similar plan as legally risky. Whatever the national politics behind it, the local effect is the same. One party deciding on its own terms how much voice the other half of Maryland gets in Congress. That's not a technical cleanup. It's redistricting on demand. And it's a precedent any future majority of either party can turn against the voters it is supposed to protect. Meanwhile, as this session is called for this purpose, Maryland carries a massive structural deficit headed towards almost $4 billion. The economy ranks second worst in the country, and our residents are facing tax and fee increases year after year. Those are the problems Marylanders asked you to solve. Redistricting wasn't on the list. History doesn't treat the slow erosion of fair representation kindly. When people stop believing their vote counts, they stop trusting the whole process, which can be devastating for all of us. I'm asking you all, regardless of party, please do the honorable thing for every voter in this state, not just the majority in the room. And I can see lots of people have already left. But I do request an unfavorable report. Please reject this House bill and Senate Bill 2100. Thank you.
Thank you. Thank you, Ms. Holtzinger. We'll move on next to Jake Taylor. Okay, Mr. Taylor, can you please start your video? And Mr. Taylor, if you're listening to the live stream, please close out the live stream for the hearing.
Absolutely. I've been following along.
Great. You have up to 2 minutes. Thanks for
Thank
paying
you. Good
attention.
afternoon. My name is Jake Taylor, and I proudly serve as an elected commissioner of the town of Bel Air, the seat of Harford County. And I come to you today both as a private citizen and in that capacity. I urge the defeat of HB 2100, a measure to amend the Constitution by creating a two-tiered system for Maryland's legislative districts, one governed by fairness and constitutionality, and the other by partisan politics. When the Governor's Redistricting Advisory Commission met in November, I testified on behalf of myself and my community that the attempt to disenfranchise the residents of the Eastern Shore and Harford County is a blatant attack on our right to self-government and representation as a region. That remains true. Now, not only do we stare down the possibility of having our representation stripped from us, but our legislators consider repealing the very provision of the Maryland Constitution which guarantees that representation. This provision, which calls for compact districts that protect communities of interest, is no dangling participle. It is an integral part of the framework by which Maryland is meant to redistrict, and it is a direct reflection of the 14th Amendment's guarantee of equal protection. The process back in November was rushed, and this process has been even more so. With only 4 days between the publication of this amendment and its public hearing, the people of Maryland have not been given adequate time to properly inspect this amendment and consider the far-reaching implications that it would have on the right of each Marylander to cast a ballot in a free and fair election. Our constituents deal now with the rising cost of living, increased taxes and fees, and skyrocketing energy bills. As we sit here during the hottest days of the year, I am deeply disturbed by this legislature's focus on consolidating political power as opposed to using the majorities they already wield to deliver relief to suffering Marylanders. The removal of this provision would open the floodgates to a level of gerrymandering previously unseen in Maryland's sordid redistricting history. Over the years, our neighbors have made plain their views on this pernicious political practice. They oppose it entirely. I urge you to reject this amendment, which would remove yet another brick from the already unsteady wall separating Maryland's Republican form of government from autocratic one-party rule. On behalf of myself and my community, the town of Bel Air, I urge you to vote to preserve our constitutional rights as citizens of Maryland and vote no on HB 2100. Thank you.
Thank you very much. We will go on to Christina Bowman. Sorry, my bad.
Yeah, Senator Gallion.
Thank you, Mr. Chair. Good hearing from you, Mr. Taylor. He was, actually worked in my Senate office for a few years, does a terrific job, but, you know, it's kind of been concerning with the upcoming retirement of Senator West. We're going to lose some great verbiage in the General Assembly. So I was glad to see, Mr. Taylor, you used the phrase dangling participle, I think. So I think maybe we see a future and some great verbiage there that we're going to lose there. Thank you.
Thank you.
Wouldn't you agree, Mr. Taylor?
Thank you for the question, Senator Gallion. It is incredibly important that the bedrock of our constitutional republic is not treated as a grammatical afterthought, and that we don't amend our Constitution for it to read as such.
All right, thank you very much, Delegate Tomlinson.
Thank you, Madam Chair. Did we lose the other people? Did I?
There's still more people.
Oh, okay. I had a question for.
You didn't push
I had
your
a question.
button.
I had a question for the woman that was maybe right before Jake Taylor.
I see you're still keeping to your tradition of late. Yeah, I think you pushed your button way too late.
Can we bring her
unfortunately.
back?
I don't know if we can bring her back.
I'll
While
give
we
her-
see if we can bring her back, we will move on to the next
I'll
person.
give her a call.
Okay, give her a call if you have her phone number. Thank you. Ms. Christina Bowman. Okay, all right. And- Hi, Ms. Bowman. If you are listening along to the bill hearing, please close out the live stream before you begin.
Will do.
Thank you.
Hold on. How do I do that?
There should be an X on wherever you're watching the,
Oh, I see.
yes.
JHR host? No.
Yeah, it would probably say that because we're in the joint hearing room, wouldn't it? Or no, maybe not. I don't want to tell her the wrong thing.
Nothing is X'd out but a JHR host. I mean, nothing
Okay.
has a cancel line in it except JHR host.
Okay. I think that there's no feedback, so Ms. Bowman, you have up to 2 minutes to provide your testimony. Thank you for being here.
Okay, so honorable legislators. When an attempt is made to change the Maryland Constitution by promoting taxation without representation to all Marylanders, I feel very invisible as a contributing voter. This special assembly created to legalize gerrymandering so it can place on the ballot in 2026's general election is both unconstitutional and illegal. It is a direct assault on my freedom of speech, freedom of religion, equal representation, and equal protection. In 2022, the court struck down the congressional map adopted in 2021, describing it as extreme partisan gerrymandering. This bill appears to completely want to abolish those guidelines, and guardrails. I believe sponsors and supporters of this bill have created an illusion that one nation under God means only one political party. It does not. On the contrary, it would forever change our Maryland Constitution into a mockery of what our founding fathers intended. George Washington stated the power under the Constitution will always be in the people. President Washington concluded the Constitution of the United States has only its keepers, the people. Do not attempt to force people to believe otherwise as you consider the value of their lives in Maryland that should not be counted when they vote. I vote. Could it be your political agendas are superseding our message? How wrong you would be to deprive we the people from learning from the founders and believing in their vote. We are not invisible. We need you to hear us on so many levels. I'm a retired nurse of 50 years serving
Ms.
Maryland.
Bowman, if you could please wrap up.
I oppose House Bill 2100 and Senate Bill 2100. My vote is precious, and as elected officials and legislators, your duty is to protect our Constitution, not vandalize or snuff it out. I urge you to reject these efforts to codify the killing of our vote. with sincere and heartfelt blessings as we celebrate our 250th birthday of these United States.
Thank you, Ms. Bowman. Delegate
You're welcome.
Tomlinson.
Thank you, Madam Chair. Ms. Baumann, can you hear me?
I can.
Okay, great. So you talked a little bit about the 2022 maps that were, or map that was thrown out. Do you see, so after, when this bill passes and the constitutional amendment most likely passes in November, do you see the new map being just as bad or maybe even worse than the map that was introduced in 2022?
I'm not an expert in maps, and so I really don't feel qualified to answer that question. I do see it as completely trying to abolish guardrails and make it more difficult for Republican voters to be heard and counted. It's already difficult, but there is a large enough population in Maryland still that needs to have their vote counted. Honestly, the map question is something I don't feel qualified to answer.
All right, thank you.
All right, thank you very much, Ms. Bowman, for your testimony. We will go back to Mr. Paul McCosby. Okay, thank you very much. He is coming in. Okay, Mr. McCosby, if you could please turn on your camera. Hello. And if you are listening to the live stream, please close it out. You have up to 2 minutes to provide your testimony. Thank you for being here.
Thank you, Madam Chair. I believe my name is Paul Cosby, as you said. I am an attorney with the Maryland Family Institute, and I believe that the people of Maryland have good cause to fear the effects of this bill. It goes far beyond the purported clarification in that it completely eliminates the possibility of any constitutional protections of any kind under the Maryland Constitution for people's rights in relation to congressional redistricting. Just as an illustration, that would theoretically mean that absent the federal requirements, that there is no prohibition under the state constitution for congressional gerrymandering on a purely racial basis. Moreover, I'm afraid it is difficult. The sponsors' statements about their personal intent to the contrary to see how the amendment can be understood as a mere clarification when it has been framed by the sponsors themselves as a response to national crisis. That crisis is not consist in the unclarity of Maryland's rules, but as they represent it, is based on the policies and decisions in Washington, D.C. and other states. The only way this bill can address these issues is if there is a change in districting, that is a new map. What the sponsors have said they need is freedom to respond. And what in this context that indicates is that they need the unrestrained ability to redistrict in a way they deem necessary to influence national politics. That means that Marylanders accustomed to the idea that their congressional representatives can represent their local community are instead to have who represents who determined by the political needs of the nation as perceived by the legislative majority. From all history and experience, we know that people tend to exercise power in ways that benefit them, even honest people.
Cosby, if you could please begin to wrap up. You have 8 seconds.
Have their judgment influenced by these presuppositions. I would therefore ask that you would return an unfavorable report and oppose the passage of this legislation. Thank you.
Senator Carrozza.
I had a question for Mr. McCosby. Is he still on?
Yes.
Okay. Thank you. I had read your testimony from the Maryland Family Institute beforehand, and you made a couple points in your written testimony about, you mentioned that the concern about the legislation, the potential to undermine the freedom of the people of Maryland. And then later in your testimony, you talked about that this bill's decision to disclaim the same basic standards applied in drawing the districts for the General Assembly can only heighten the inevitable concern of this deliberate push for unconstrained power, which I think you're alluding to one-party dominance. But could you elaborate on both the point that you made about undermining freedom and the point about the unconstrained power?
Yes. On the one hand, it undermines the freedom of the people of Maryland. These are really two sides of the same coin. It undermines their freedom because it undermines their political power when their vote is merely counted on the basis of what a legislative majority decides. That is to say, when your votes are assigned to the legislate to the congressman that is intended by the majority in the General Assembly. Now, this goes in fact beyond one-party rule. It also involves a control of a particular element of a single political party, because the districting is controlled to an enormous extent by who is in control of the processes in the General Assembly itself. So this actually undermines even the power of the rank and file of a majority party, whereas, of course, it entirely shuts out the votes of a minority party, not to mention, of course, independents.
Thank you.
Does that answer your question?
Yes, thank you.
Thank you.
All right, seeing no further questions, thank you very much, Mr. McCosby, for your testimony. We'll move on now to Laura Bogley. Hi, good afternoon, Ms. Bogley. You have up to 2 minutes for your testimony.
Thank you, Madam Chair, and the members of the committee that have stayed, the few that are left for this long day. I'm Laura Bogley, a District 1 resident, and on behalf of the Board of Directors of Maryland Right to Life, I strongly oppose this bill, which, if enacted, would disenfranchise an entire class of human beings and put innocent human lives at great risk. If enacted, this bill could finally give pro-life advocates the perfect equal protection claim to bring before the Supreme Court of the United States. This legislative scheme is not just an abuse of the constitutional amendment process. It is a blatant attack against the fundamental freedoms of Catholics and pro-life voters in Maryland. By targeting the sole pro-life member of Congress, this amendment would completely disenfranchise pro-life Marylanders, both Republican and Democrat. But most importantly, this action would deny the equal protection rights of more than 40,000 human beings, many of whom are Black children, who are killed each year in Maryland through abortion violence. By taking this action, you are targeting their human and civil rights and diluting the vote of nearly 1 million voters who are a voice for these voiceless. If a legal challenge to your gerrymandering scheme based on the human and civil rights of unborn children reach the U.S. Supreme Court, it may just survive the standard of review for Rucho versus Common Cause of 2019. This could finally give pro-life advocates the platform to fight for the equal protection of unborn children. This foreseeable litigation could cost more than 10 million taxpayer dollars, leaving Democrats no credibility to promise affordability. Maryland's overall performance in prenatal and maternal health falls in the mid to low range nationally, with persistent racial and geographic disparities. To address these disparities, the Maryland General Assembly should be laser focused on making maternal and infant care more affordable. The state should instead use this money to provide a complete care package for 2,870 mothers and infants through the baby's first year of life, completely funding full prenatal imaging and vitamins, plus a full year of diapers and formula. For these reasons, we urge you to reject these bills, to uphold your oaths of office, to protect the Constitution and the rights it guarantees, and to respect the voices of all Maryland voters. Thank you.
Thank you. We have a question from Delegate Tomlinson.
Thank you, Madam Chair. Nice to see you, Ms. Bogley. That was a lot of information. I know you had to cram into 2 minutes. Can you just kind of further expand on that? Because, like I said, it was a lot of stuff. But how, just a little bit more on how this is going to, how if this bill passes and the constitutional amendment gets voted on by the voters, how this is going to affect the pro-life movement.
Yes, thank you, Delegate Tomlinson, for the question. I think President Ferguson said it himself. A lot of this scheme was motivated by request of pro-abort women, pandering to pro-abort women who wanted to try to stop the co-chair of the Congressional Pro-Life Caucus, Congressman Andy Harris. That was absolutely their motivation. So this is not as much about partisan politics as it is about content discrimination and denying the equal protection of unborn children, an idea not yet fully litigated by the Supreme Court of the United States. So by enacting this, putting it on the ballot, even though you've missed the July 1st deadline, and having it ratified by voters, you are teeing up the perfect storm of having a Supreme Court review of whether or not the unborn children in this country are due the equal protection under the law, which includes the laws of Maryland. So again, this is about the civil and human rights of those unborn children, many of whom are Black babies. More than 50% of abortions are by Black women in the state of Maryland. So we know this is having a disparate impact on the lives of these Black children. This is absolutely an equal protection argument. We think that the Supreme Court would look into it. So we want to encourage Democrats, especially in the General Assembly, when you're thinking about this bill, think about prioritizing the money you would waste in this litigation for actually helping to support mothers and infants in the state of Maryland.
Thank you, Ms. Bogley.
All right, thank you very much, Ms. Bogley. We will move on to Ms. Linda Dorsey Walker. Going back to her. Good to see you again, Ms. Dorsey Walker.
Yes,
You have up to 2 minutes to testify. We're ready to hear your testimony.
sure. Again, my name is Linda Dorsey Walker, and I'm speaking on behalf of the New Horizons Group in Baltimore County. I'm a 9-term elected member of the Baltimore County Democratic State Central Committee, which means I've already served 32 years, and I've appointed many of the people who have served in the General Assembly over the course of those 32 years. But today I want to talk about the experience we had with Vote for More, a ballot initiative which I chaired until last year, which changed the course of Baltimore County history. It was our defining moment. Just as in the case of House Bill 2100, throughout the time that we collected our over 12,000 signatures, we had many people who said, let us see the map. We want to see the map. We want to see the map before signing. And we had to explain that what we're talking about is a rule change. We're going to amend the charter in Baltimore County to define how many districts there would be, how many hours a council member has to work, salary, all those kinds of things, the size of commissions and so forth. And many people were upset because they wanted to see a physical map, but in the end, by going the route that we did, it easily passed with 80% yes vote on question A in November 21. This is what I want to tell you about 2021. In that year, I was the only non-member who participated in literally every single meeting of the governor's Maryland Citizens Redistricting Commission. I also participated in every single meeting of the RAC, which was the Legislative Redistricting Advisory Commission. So while I've heard many people talking today, oh, this is so, I'm disheartened because you all came today and had to give up
Ms.
your
Dorsey
time and they're not
Walker,
going
you
to
have
do the
10
same.
seconds to wrap
If
up.
those folks were interested, they should have come out during that period of time. Please understand this. We had people who wanted to cross the bay, but we were told it's an unwritten rule. We don't cross the bay. We had people who wanted to
Ms.
split
Dorsey Walker, your time is up.
jurisdictions up, but we were told it's an unwritten rule.
Ms. Dorsey Walker, your time is
Let me
up.
just say one other thing.
Your time is
Give
up. You're
everyone,
past your
every
allotted time.
citizen access to Maptitude. Maptitude was through our state planning.
Thank you very much, Ms. Walker. Okay. Are there any questions for the panel witness? All right. Seeing no more questions.
Okay, I want to thank the Glee Committee, Chair Wells, my members, for closing in on, well, they went to make 5 hour worth of riveting testimony, and I will yield back to you, but thanks for everybody for sticking around.
Absolutely, and I just want to express my thanks as well to Chair Feldman and to the senators for your great debate and questions, and for us all being here today together. So with that, that will conclude our joint hearing on HB 2100. Glee will reconvene in 10 minutes, so we'll have a short recess for us to go get water, stretch our legs, and then we have a vote session that will begin in about 10 minutes, so about 5 p.m.
Okay, in the Senate, for those of you, we will be convening tomorrow morning in the Senate chamber at 10:30. So we're good.